Hearty welcome to Jnanarjane, Empowering Excellence. Friends, we have arranged this 2 days workshop on private trust. Today, we are covering private trust fundamentals, principles, and legal framework, succession through private trust, and governance trust deed of private trust. And to enlighten us on these topics, we have two eminent speakers from Bangalore. They are really expert on this topic, private trust and succession planning. CA Sheshadri sir is with us on behalf of Bangalore branch and on behalf of all the participants. Hearty welcome to CA Sheshadri sir. Hearty welcome, sir. And another young eminent chartered accountant and a specialist on the topic, CA Bharadwaj Sheshadri is with us on behalf of Bangalore branch and on behalf of all the participants here. Hearty welcome to CA Bharadwaj. Hearty welcome, Bharadwaj. Friends, we also have our Vice Chairman Srinivas with us on behalf of Bangalore branch and all the participants. Hearty welcome to CA Srinivas. Hearty welcome, Srinivas. We have with us CA Srihari is with us. Today is the program coordinator. Hearty welcome to Srihari. Friends, participants, you are the reason for this program. This succession planning, we last 2 months ago, we conducted a detailed workshop on that. Today, we thought it appropriate to have this private trust alone, have a further study on that and understand in detail. This is a lucrative practice in future. That's what I believe. And that is the reason I thought it to educate all our members about this trust and succession planning. So in that regard, we arranged this 2 days program and all of you register for this program to learn and understand and take up this lucrative practice. Hearty welcome to each one of you. Friends, I'll take a minute of you to update about our some other upcoming programs. On 16th, 17th, and 18th, 3 days we have arranged information technology workshops. Again, there we are going to all the new technologies which are lot many are in news. So I request each of one of you to register that program. Again, there are many other programs lined up in this month. I request please visit bangalore.icai.org for all the updates and all the new programs. Hearty welcome once again to all our eminent speakers, Vice Chairman and CA Srihari. Over to Srihari. Please introduce our eminent speakers.
Unmute.
Thank you, sir. It is my privilege to introduce two speakers of the day. First speaker being K. Sheshadri, sir. He has been practicing as a chartered accountant from 1980. That is a whopping 41 years in Bengaluru. Since 1989, he has been in practice with his wife in their firm, Messrs. Sananda and Sheshadri. His work extends to advice and consultation of income tax laws, GST, corporate laws, FEMA, NBFC regulations, and FCI. He has appeared before and he continues to appear before the ITAG, before whom he has reported cases to his credit. He has represented individuals, listed clients, unlisted commercial entities, NGOs, and so on before the direct tax and indirect tax assessing and appellate authorities. His firm is consulted by fellow chartered accountants, large NGOs, education institutions, hospitals, credit cooperatives, etc., and including listed companies. He has handled wide-ranging work relating to non-governmental organizations, that is NGOs, and also charitable trusts. That makes him an eminent speaker for the topic of the day. He was also engaged in financial stock taking, that is a process under which the firm evaluates, investigates, or audits NGOs on behalf of their overseas and local donors. He has so evaluated more than 75 NGOs. The early years of his practice involved a wide variety of audits, including audits of listed companies and banks. He has also been involved in academic work, such as the publication of studies or reports, including legal changes needed to aid and facilitate microfinance activity in India, guide to audit of microfinance sector, and so on. With this introduction, I welcome K. Sheshadri to the program. Next is his son, Bharadwaj Sheshadri, who was born in 1992 to this couple of Shri K. Sheshadri and Srimati Sunanda. He pursued his articleship with Messrs. Verma and Verma Chartered Accountants in Bengaluru, and he qualified as a chartered accountant and then also took a bachelor's degree in commerce. He took a bachelor's degree in law from the Karnataka State Law University in 2018 and also obtained a scholarship for securing the highest marks in criminal law. He practiced as a chartered accountant between January 2015 and October 2018, after which he enrolled as an advocate in April 2019. And since then, he has been in legal practice from December 2019. He began appearing before the Commissioner of Income Tax Appeals at the young age of 22 and before the Income Tax Appellate Tribunal at the age of 23. He presently practices before these authorities and appellate authorities under the indirect tax laws, the High Court of Karnataka, and also has matters before this estate. He has reported orders of Income Tax Appellate Tribunal and the High Court of Karnataka to his credit. His areas of practice extend to drafting as well as consultancy in matters relating to commercial contracts, succession, income tax laws, GST, company law, FEMA, FCRA, and so on. He has a keen interest in writing and speaking and has multiple published technical and non-technical articles to his credit. He has co-authored the third edition of the book Trusts by C.R. Rao, published by Messrs. Puliani and Puliani, where he authored the part on the taxation of trusts. He enjoys public speaking and has been engaged with professional and other organizations, including branches of the SIRC, to talk on technical subjects. He has also been invited to judge the moot court competition, such as the prestigious Surana and Surana National Corporate Law Moot Court Competition at the JSS Law College, Mysuru, which he has judged for 6 consecutive years. With this brief introduction, I welcome you, sir. I hand it over back to B.T. Shetty, sir.
Srinivas, you want to talk something?
Yes, sir.
Please go ahead.
Happy evening, respected chairman and speakers of the day, and Sri Hari. I wish you all and all the members present here for the virtual meeting. I wish you all happy Gauri Ganesha festival. On this auspicious day, we have two eminent speakers, none other than Sheshadri sir and Bharadwaj Sheshadri, to speak on private trust. As starting this program, discussing with Sheshadri sir and other friends, this is a very core area and very important, very hot topic to practice, and very few people are practicing in Bangalore on this subject, and in that sir is very specialized in those subjects, and it's a very good scope for practice to have this program. Really, we are privileged to have both the speakers on this occasion. I welcome once again our speakers, Sheshadri sir and Bharadwaj Sheshadri, and all the members joining virtually. Thank you. Over to Chairman sir.
Over to Sheshadri sir or Bharadwaj.
Namaskara. My thanks at the outset through B.T. Shetty sir, through Sri Hari and every other members of the managing committee present here to the Bangalore branch for having invited me to speak on this occasion. Before I begin, I must also note with pleasure the presence of Sri R. Keshavdas, partner of Mrs. Verma and Verma, who was actually my principal in my articleship. I'm very happy to note that he is present today. There is an opinion that this law on private trusts is extremely complicated or elaborate. Part of my objective today is to disabuse you of this notion. It is true that the law is somewhat unknown to us, but it is easy enough to learn because it is only the foundational or elementary principles of the law that are nuanced. Once these foundational principles are understood, everything above that on the law are very easy to conquer, very easy to understand. What is more advantageous is that these foundational principles lie in a very narrow compass. It is much like a skyscraper. It is not a large plot of land on which high buildings are constructed. It's a very narrow compass on which there is a skyscraper. To use an analogy, It is something like the new student of accountancy learning the concepts of debit and credit and capital and revenue. These concepts are certainly very difficult for him to understand in the beginning. But when he gets a grasp over these 2 or 3 foundational concepts, a wide array of accounting principles opens up to him later on. He can understand everything from, say, something as simple as fixed assets to something as complicated as operating and financial leases. So these foundational principles I will spend some time on, say the first 10 or 15 minutes. We will appreciate that from a theoretical perspective. And thereafter, I will take you through the provisions of the Indian Trusts Act and the law on trusts as it stands today. Now, there are 2 categories of branches of the law. Accountants, the kinds of law that you typically deal with are laws which are almost exclusively governed by statutory law. That is where there is an enactment of the parliament or the state legislature governing it. Income tax, GST, FEMA, FCRA, banking, insurance, all of these fields of the law are governed completely by statutes. On the other hand, there are somewhat what you may describe as the slightly older fields of law, like contracts, transfer of property, negotiable instruments, and all these branches. If you look at all these branches of the law, it is not as if the statutes created too much new law. They did certainly create some law, but all these transactions were undertaken in the common law much before the statutes came into existence. The trusts law also falls in this second category. In British legal history, trusts have been known to exist at least since the 13th century. This is well before even Britain enacted any law governing the law of trusts. And it is certainly well before 1882 when our Indian Trusts Act was enacted. Therefore, to understand the law on trusts, we must first appreciate the common law on trusts and then come to the statute. To understand what a trust is, we must understand the jurisprudential concept of a trust before we come to the definition of the trust in the definition of the term trust in the Trusts Act. In fact, I would go so far as to say that the worst way to understand what a trust is to read the definition in the Trusts Act straight away. Let me begin with an example. Let us say that I am in possession of immovable property being land and building. And let us also say that I have a registered title deed in respect of that land and building in my custody. And all the original mother documents and earlier documents of title, say for the last 150 years, are also with me. There is a clear undisturbed chain of title over this long period. I am also, if the property is located in the jurisdiction of the BBMP, I have a khata in my name, I'm paying property tax in my name. These last 2 facts are not relevant to ownership, but the first few, that is possession and documents of title, virtually conclusively establish my ownership. There is also no contrary claim. In these facts, my ownership is actually of 2 kinds. First, I have what is called legal ownership. The most important symptom of legal ownership is that where any suit or proceeding is to be instituted in respect of the property being owned, that suit or proceeding must necessarily name me as a party. This immovable property itself is not a person, and therefore it is not a party capable of appearing before the court. Therefore, if somebody wants to take over possession of that land on some ground, then a suit or other proceeding has to be instituted against me, naming me as the defendant. So I am undoubtedly the legal owner of the property. There is another dimension to ownership. The first is legal ownership. The second dimension is what is called beneficial ownership. This beneficial ownership involves the entitlement or enjoyment of all the rights and benefits that arise from the land. What can I do with this immovable property? Just about anything I want, so long as it is legal. I can sell it, I can cultivate it, I can build a house on it, I can dig it up. All the air above it is my, I have a right over. All the, subject to certain special enactments, the minerals and all that underground also are within my purview. So in all contexts of ownership, bar one, not one, bar a few, you will find that legal ownership and beneficial ownership vest in the same person. As in the case of this immovable property, so is also the case of, for example, the shirt I'm wearing or the earphones I'm using for this seminar. A trust, the most characteristic or the most definitional characteristic of a trust is that it separates legal ownership from beneficial ownership. And this has been explained absolutely beautifully in the treatise Salmond on Jurisprudence. I have read maybe 20 or 25 different definitions of the term trust, but nothing is as clear and as elegant as Salmond's definition. So before I read that definition out, it's not a definition actually, it's an explanation. Before I read it out, the key principle of a trust is the separation of legal ownership from beneficial ownership. Salmond's explanation reads, a trust is a very important and curious instance of duplicate ownership, which allows for the separation of the powers of management and the rights of enjoyment. Trust property is that which is owned by two persons at the same time, the relationship between the two owners being such that one of them is under an obligation to use his ownership for the benefit of the other. The former is called the trustee, and his ownership is trust ownership. The latter is called the beneficiary, and his is beneficial ownership. The trustee is destitute of any right of beneficial enjoyment of the trust property. His ownership, therefore, is a matter of form rather than substance and nominal rather than real. In legal theory, however, he is not a mere agent, but he is an owner. He is a person to whom the property of someone else is fictitiously attributed by the law. As between trustee and the beneficiary, the law recognizes the truth of the matter. That is, as between these two, the property belongs to the latter, the beneficiary, and not to the trustee. But as between the trustee and third parties, this fiction prevails. The trustee is clothed with the rights of the beneficiary and is so enabled to personate or represent the beneficiary in dealings with the world at large. Therefore, the principal definitional characteristic of a trust is that there is separation of legal ownership and beneficial ownership. The legal ownership vests in the trustee and the beneficial interest vests in the beneficiary. So the trustee can enforce his beneficial interest against the beneficiary. But if any third party seeks to enforce a right in respect of the trust property, the beneficiary cannot be named as a defendant in the suit. It is only the trustee who must be named, subject to various provisions in the Code of Civil Procedure, which we won't get into now. Now, therefore, the legal ownership is clearly with the trustee. So everybody has always told us that a trust is not a person. The question is, if the trust is not a person and a trust is not a property, then what is a trust? From this understanding of the basic concept of a trust, it is clear that a trust is an arrangement or a phenomenon of some kind. In fact, in Salmond's seminal work, he deals with the concept of trust in the chapter ownership under the heading forms or types of ownership. This is because trusteeship or the arrangement of a trust is predominantly a rearrangement or a modified version of ownership. It is in this sense that trusts are distinguishable from contracts and agency. So far as a contract is concerned, whatever you two contracting parties may do, the property vests only in one of the parties. Either it vests in one party or the other, or in the course of the contract, it passes from one party to the other. But there is no stage in a contract or in an agreement of any sort where the property simultaneously vests in two people. That is unique to a trust. The second point is the principle of privity of contracts. This is not, this really proves the distinction between trusts and contracts. If a person is to be affected by a contract, that is, if he is to incur liabilities or secure rights, then he necessarily must be a party to the contract in accordance with the principles of privity to contract. Whereas in a trust, the beneficiary secures a beneficial interest in the property, although he is not even required by any law to sign the trust deed. In fact, a beneficiary acquires a beneficial interest in the property even if he does not have notice of the trust. If the property vests in a trustee and the trustee holds it for the beneficiary already has the beneficial interest, whether he knows about that interest or not. So you cannot apply the principle of privity of contract to trusts. When you compare trusts with agency too, the position is the same. Again, here, the property vests in the case of trusts, property vests simultaneously in two persons, whereas in the case of agency, the property normally vests only in the principle, the agent only being an actor on his behalf. Secondly, a trustee can give good title to a bona fide purchaser who does not have notice of the trust, but an agent cannot do that unless the purchaser has notice of the agency. Therefore, on this fundamental jurisprudential common law based understanding of the trust, the chief characteristic of a trust is a separation of legal and beneficial ownership. Let us now look at how the Indian Trusts Act addresses this and how it defines a term trust. A trust is an obligation annexed to the ownership of property. Let's stop here. We won't read the full definition yet. So, first of all, the separation of legal and beneficial ownership means that the law, whenever the law refers to the owner of trust property, it refers necessarily only to the legal owner of the trust property, who is a trustee. The beneficial owner of the trust property is never referred to in the law as the owner. It is only the trustee who is the owner. Now, a trust, this definition says, is an obligation annexed to the ownership of property. Therefore, the ownership of property vests in the trustee, and annexed to that ownership, the trustee has an obligation to use it only for the benefit of the beneficiary. You should note that it is an obligation annexed to the ownership of property. It is not an obligation annexed to the property itself. If you want to have a charge, for example, you want to mortgage immovable property, that is an obligation which is annexed to the property. But here the obligation is not annexed to the property, it is annexed only to the ownership. Therefore, if the property was to change its character in due execution of the trust, the obligation would still continue although the property has changed, because it is an obligation annexed only to the ownership. A trust is an obligation annexed to the ownership of property and arising out of a confidence reposed in and accepted by the owner. The owner again is the trustee. We see these words donor and donee, payer and payee. The same way, the word truster does not exist, but the truster, so to speak, is the settler or the author of the trust. This settler or author reposes confidence in the trustee. Therefore, the truster or author or settler puts his trust in the trustee who receives the trust, which is why he is called a trustee. This is the confidence reposed by the author in the trustee is what gives the trustee the name trustee. A trust is an obligation annexed to the ownership of property and arising out of a confidence reposed in and accepted by the owner. Therefore, a trustee cannot be compelled to be a trustee. He has a right to accept or decline whether he wants to be a trustee or not, or declared and accepted by him. Now, this is very interesting. Here, we have read three clauses of this definition so far. The first clause is a trust is an obligation annexed to the ownership of property. The second clause is and arising out of a confidence reposed in and accepted by the owner. The third clause is declared and accepted by him. Where confidence is reposed in somebody, that means that there is another person who is reposing the confidence in this somebody. Where confidence is declared and accepted by him, that means that he is himself declaring that confidence and accepting it himself. What this indicates is one question which comes to us often in practice: can the settler himself be a trustee? This definition would indicate that the answer is yes. I will, however, address this in detail a little later in dealing with section 7, 8, and 9. So it is a arising out of confidence reposed in and accepted by the owner, or declared and accepted by him for the benefit of another. This another, therefore, is the beneficiary, for the benefit of another or of another and the owner. Here again, the same thing is happening. The owner is who? The owner is a trustee. So the trust must be either for the benefit of another, or it must be for the benefit of another and the owner, which means a trustee himself can be a beneficiary. So prima facie, there are two conclusions here. First, that a settler can be a trustee, and second, that a trustee can be a beneficiary. But nevertheless, we will deal with this later in detail. So I will just read this definition once more to conclude. A trust is an obligation annexed to the ownership of property and arising out of a confidence reposed in and accepted by the owner, or declared and accepted by him for the benefit of another or of another and the owner. At this stage, I would like to make one point, though it's not strictly related to today, because today we're dealing only with private trusts. If you look at the section 1 of the Indian Trusts Act, it says that the Act does not apply to public religious or charitable endowments. There are, to my knowledge, at least 3 judgments of high courts, and these judgments have come over the last 80 to 100 years, which hold that by virtue of this provision in section 1 of the Act, the Trusts Act does not apply to public and charitable trusts. Today, at least on the grounds of the stare decisis doctrine, it is a safe conclusion to reach that the Trusts Act does not apply to public and charitable trusts. However, is that the actual position or not? That is something which requires deeper examination. It is not strictly within the scope of today's seminar, so I will not be covering it. 1.5 hours in any case is too short for all this. But nevertheless, it may be a safe conclusion to reach, irrespective of whether it's completely correct or not, that the Trusts Act doesn't apply to public or charitable trusts. Now, what is the law that governs private trusts? Certainly, the Indian Trusts Act governs private trusts. However, as I have pointed out, the instrument of trusts have far predate the any statutory enactment on trusts. Therefore, the common law principles which govern trusts continue to govern trusts today, even after the enactment of the Indian Trusts Act. All these statutes, some of the branches of law which I mentioned, the Transfer of Property Act, the Negotiable Instruments Act, even the Partnership Act, the Trusts Act, etc. All these statutes do not add too much to the new law. They may modify the law as the law existed before the statutes came into force, but they do not altogether obliterate the common law. So if the Trusts Act is silent on some principle, you will have to go searching for the common law principle on that point to reach an accurate conclusion. So the best example of that is the decision of our High Court, the Karnataka High Court, in CIT versus Indumati R. Kirloskar, reported in 176 ITR 422. There are very many propositions in here in this judgment, which you will see later, but I deal with this judgment for one very limited point. Section 9 of the Indian Trusts Act says that if somebody is a proposed beneficiary of a trust, that is, a trust has not yet been settled, but it is an executory trust. That is, some things have been done to create a trust, but the creation of the trust is not complete. At this stage, Section 9 says that the beneficiary has the power to renounce his interest and say, I don't want this beneficial interest. I'm not interested in this trust. So don't count me in. The argument made on behalf of the Income Tax Department before the High Court was, Section 9 says that only a proposed beneficiary can renounce his interest, but a person who has already become a beneficiary cannot renounce his interest because Section 9 restricts its operation to proposed beneficiaries. The Honorable Karnataka High Court disagreed with this, rejected this contention, and held that it is true that Section 9 says only so much, but Section 9 is only an enabling provision. It is not a disabling provision. And in common law, even after a beneficiary secures his interest, he can always renounce it. And there is nothing in the law, in the Indian Trusts Act, which negates this common law principle. Therefore, as I said, when you're interpreting laws like this, you cannot stop with reading the Act. You have to find out the underlying common law principle to ensure that you understand the law fully. Therefore, this graphical representation summarizes the essential ingredients of the trust. I don't need to go into this in great depth. The parties to the trust and the essential facets of a trust, therefore, are an author or a settler. I suppose I didn't deal with author or settler in too much depth. Trustee and beneficiary, we have understood. The trustee is the owner of the property. Who then is this author or settler? The author or settler is, to put it simply, the earlier owner of the property. That is, he held the property and he desired that a trust be created for the benefit of the beneficiary. Therefore, he relinquished the legal ownership in the property and transferred it to the trustee, and thereupon the trustee became the owner. So the author or the settler is the term I used earlier, which is of course bad English, but it's convenient, is the truster. He is the person who creates the trust. Then there's a trustee and beneficiary. The property of the trust, there is a property of which the trustee becomes the owner. This is known as the subject matter of the trust or the trust property. So these are the basic concepts relating to trusts. Types of trusts, this is mainly for academic interest, bare or simple trusts. These are trusts where the trustee does not have any power to do anything. He doesn't have the power, any discretionary power. He doesn't have the power to take any decisions. He is merely a legal owner of the property. He just has to sit and own the property and hold it for the benefit of the beneficiary, and that's all. A special trust is a trust where the trustee has a power to take various decisions with respect to the property and to exercise any kind of discretion. Specific and discretionary trusts. This is a subject that is relevant to chartered accountants in particular. Of course, it will be dealt with presumably by Sri Sangvi tomorrow. I think Appa also will deal with it briefly day after. Now, a specific trust is a trust where the identity of the beneficiaries and the shares of the beneficiaries are clearly known and defined. Where that is not the case, it is called a discretionary trust. Now, this resulting implied and constructive trust is a very important point. I spent some time on it. Now, in all these cases that I have dealt with, the settlor transfers the property to the trustee. He does this act voluntarily. A transfer, the definition of the term transfer, except for section 247 of the Income Tax Act, even there it is there. The definition of the term transfer necessarily contemplates two things. One is all transfers are inter vivos. That is, both the transferor and the transferee are living persons. This is there in the Transfer of Property Act. And for these purposes, a corporation is considered to be a living person. So transfers must be inter vivos. And secondly, the transfer must have the volition of the transferor. It must be an act, a voluntary act by the transferor. Therefore, a compulsory acquisition by a court or the government, or succession by means of whether it's a testate or intestate succession, all these are not transfers because there is no volition or any act on part of the transferor involved. In fact, this is why if you look at the Companies Act, there are two successive sections, or rather there's one section which deals with transfer and transmission of securities. Transfer is inter vivos and voluntary, transmission is neither of these two. There are situations where the law will itself imply a trust, even if you did not intend to create a trust. A very important example of this is the judgment of the Supreme Court in the case of Prasad versus State of West Bengal, which is the citation is available on your screen. In this case, a husband and wife executed a joint will. By this will, they made certain bequests. We will not go into the details of that bequest. Now, after the husband passed away, the wife said, listen, I want to amend the will now, I want to revoke it, and I want to execute a fresh will, bequeathing that property upon some other person. The question was whether this is permissible or not. One of the most important principles in the law of succession is that any person has very wide powers with respect to wills. He has the power to modify and revoke the will at any time. In fact, this is why it is called a will. It is literally the will of the person authoring or the testator. So the Supreme Court said that we are reluctant to restrict the power of the testator to revoke a will. So they held that the wife will certainly be permitted, despite executing a joint will, to revoke that will to her extent and execute a fresh will. The Supreme Court even held that the wife would be permitted to bequeath this property upon somebody else other than the person who is named in the joint will. But the question that then arises is, what is the fate of the legator, of the legatee who took under the joint will? That is, under the joint will, let's say A received the property. One of the people died and suddenly A loses his right on the whim of the second person. Then what is the sanctity of that right which this legatee has secured? Therefore, what the Supreme Court did, they said that if after the death of the husband, instead of maintaining that bequest in favor of A as per the joint will, if the wife chooses to make a bequest in favor of B, then B would hold this property in trust for A. Therefore, rather than the property going directly to A, B would hold it as a trustee. B would not enjoy any beneficial interest, and the beneficial interest will be fully in the hands of A. The net effect is the same. The net effect is the same to the extent that A only ultimately, in fact, de facto A enjoys the property. However, the Supreme Court said that the law would imply a constructive trust, that is, B would be the trustee and A would be the beneficiary, so that the right or the freedom to execute and modify testamentary instruments and wills is not abrogated in any manner. Then there are private and public trust. This depends on the objective. Then the executed and executory trust. This is the same as the executed and executory contracts. That is where a trust is fully settled or whereas a trust has not fully been settled yet. We will deal with this term execution a little later. Now we come to the positions of the parties. It is at this stage that we get into the provisions of the statute itself. First is the settler. In order to be a settler, he ought to own property and he ought to be competent to transfer that property to the trustee, assuming that he is himself not the trustee. Therefore, Section 7 says that a settler must be competent to contract. The natural question that arises is, what is the position of a minor settler? If there is a minor child who has property, of course, with the guardian controlling the property, can that minor child settle property upon trust? Section 7 says yes, but property can be settled on trust. A trust can be created on behalf of the minor only with the permission of the principal civil court of original jurisdiction. So a minor can settle a trust, but you need the civil court's approval. The other point is what happens to the settler at the end of the life of the trust. Let us assume that the settler has settled property upon trust, naming his child as the beneficiary. And he says the purpose of the trust is to fund his postgraduate education. The child either completes his postgraduate education, in which case the purpose of the trust is fulfilled, or he fails to undertake postgraduate education, in which case the purpose of the trust is frustrated. What happens in these two circumstances? Section 83 of the Indian Trusts Act says that if the trust is incapable of being executed, or if the property of the trust is not exhausted, although the trust is completely executed, then the trustee will hold the property for the benefit of the settler. In other words, where the trust cannot be executed or has completely been executed, but the property is still not exhausted, the beneficiary will become the settler. Therefore, the settler and the beneficiary will be the same person. If you notice, we dealt with specific implied and constructive trusts. Section 83 has the effect actually of itself creating a constructive trust in favor of the settler. So that is so far as the settler is concerned. What is the position with respect to the beneficiary? Beneficiary's role in a trust is very simple. He does not have to do anything. He merely sits and enjoys the benefits of the property. So whereas the settler has to be somebody who is competent to contract, Section 9 stipulates that it is sufficient if the beneficiary is somebody who is capable of holding property. A minor and an insane person are capable of holding property even if they are not competent to contract. So the qualification for being a settler is much higher than the qualification for being a beneficiary, because the role of the settler is more significant than the role of the beneficiary. What is then the position of the trustee? I will finish that before coming to announcement and disclaimer. The trustee, like his position in the transaction structure, even as to his qualifications, he lies between the settler and the trustee, settler and the beneficiary. The settler must be somebody who is competent to contract. It is sufficient if the beneficiary is capable of holding property. So far as a trustee is concerned, if he is required to exercise any discretion, then he must be competent to contract. But if he is not required to exercise any discretion, then he need not be competent to contract, but he must be capable of holding property because he is the legal owner of the property in question. Therefore, a settler has to be competent to contract and, needless to say, has to be capable of holding property. A beneficiary it is sufficient if he is capable of holding property. A trustee lies between them. He needs to be competent to contract if he is exercising any powers, particularly discretionary powers. This is the law stated in Section 10. Now we come to renouncement and disclaimer. I've already addressed the judgment of Indumati Kirloskar, where Section 9 was interpreted and the common law is interpreted. The beneficiary, of course, has a right to say, I'm not interested in the trust, I wish to disclaim. How does Section 9 say that this disclaimer has to be done? You can address it to the, you can simply write a letter to the trustee and say, I disclaim. Or you can set up a claim which is contrary to your interest in the trust. Let me give you an example. Let us say that a father settles 50% of settles 50% of the property, settles some property upon trust, saying that they must go, the beneficiaries must be his two sons in equal shares. One of these sons dies, and thereafter the father dies. The surviving son institutes a suit saying that by virtue of the death of his brother and his father, he has a legal right as a matter of intestate succession to the whole of that property. Where if he's able to succeed in such a suit, then he is claiming 100% of the property, whereas a trust entitles him only to 50% of the property. This claim is therefore inconsistent to the trust. The moment he succeeds in such a claim, he renounces his interest ipso facto in the trust. Now, this is the case of a renouncement of interest where there is no beneficiary, where there is only one beneficiary. But there are various other complicated questions in this context. Very often trusts are settled where beneficiaries take benefits in serial order. That is, A takes benefit after him B, after him C. What happens if A relinquishes or renounces or disclaims his right? Will B and C's rights be defeated, or will B and C's rights arise immediately? The answer is the latter. This is known as the principle of acceleration. It's a fairly obvious term because B was supposed to get his rights only much later in the future, but by virtue of A's renouncement of his rights, B secures his rights immediately. Therefore, there is an acceleration of his rights. So this principle of acceleration is well recognized in the British law, and it is recognized in India too. There's only one rider for this principle of acceleration, which is that the right in the second and third beneficiary must be a vested right. It must not be contingent upon some uncertain future event. If it is so contingent, then the principle of acceleration will not apply. And once again, I will point out to you to exercise great caution, because there is nothing in the Indian Trust Act which even deals with this principles of acceleration. It is something you only have to find from the common law. That is why you have to buy extremely heavy commentaries. Mukherjee's commentary on the Indian Trust Act, which is what I use, I find to be very useful. So this is where there are beneficiaries taking in serial order. What then happens if there is only a single beneficiary and he renounces his interest in the trust? Therefore, this is a sort of suspended animation kind of position where the settler has settled property upon trust, the trustee is holding the property, and there is no beneficiary. In such a situation, again, the Indian Trust Act does not clarify this point, but the common law position is that the trustee will continue to hold the property will continue to be held under a trust, but it will be held under a trust for the benefit of the settler. That means if there is a trustee and there is no beneficiary, then the settler becomes the beneficiary. I hope that is clear. Now, I didn't actually plan to discuss this, but let me complicate it one step further. What happens if the settler is himself the trustee? There is a sole settler who is himself the sole trustee. We have already discussed that this is possible, and anyway, the last point on your screen, we will address that too. What if there is a sole settler and a sole trustee? He himself is the sole trustee, and the beneficiary renounces his rights. In such a case, if the trustee holds the property for the benefit of the settler, the trustee is actually holding the property for his own benefit because he himself is the settler. It is at this stage that we must be thankful that we refer to Salmon jurisprudence first and not the definition from the Trust Act first. Because if you read the definition from the Trust Act, this situation cannot be answered. What is the most essential or basic characteristic of a trust? It is the separation of legal ownership from beneficial ownership. In a situation where the settler and the trustee are the same person and the trust is held for the benefit of the settler, Therefore, the trustee and the beneficiary and the settler are the same person. The legal ownership of the trustee and the beneficial interest of the beneficiary come back together, and by virtue of the law, there ceases to be a trust. In other words, if the settler and the trustee is the same person and there is no beneficiary, there is no trust because the trustee holds it for himself. He becomes the legal owner, he becomes the beneficial interest holder, and he therefore becomes the absolute owner of the property. The trust automatically ceases to exist. Next, we come to trustees' disclaimers. Section 10, I think it is 10, I will clarify, says that nobody can be compelled to be a trustee. But equally, section 10 says nobody is bound to be a trustee. Therefore, when trusteeship is offered to somebody, he must either elect to become a trustee or elect to renounce, disclaim and say, I don't want to be a trustee. So, but this right to disclaim trusteeship is available to him only before he accepts. Once he accepts trusteeship, once he begins acting as a trustee, once he holds that office of a trustee, thereafter he cannot renounce a trusteeship once he has accepted it. This is also there in a provision which we will deal with. It's there in a provision of the Act which we will deal with later. Now that you are sufficiently confused, let me confuse you a little further. I trust that I am the only one confused, but we will see. Can one person act in two capacities? Can a settler be a trustee? We have already seen that the settler can be a trustee. In this situation, what happens? Let us again go back to Salmon. Let us go back to first principles common law. Let us forget about the Trusts Act. When a settler has to create a trust, he is giving up the ownership of the property. He gives up the ownership of this property by transferring it to the trustee. If he is himself the trustee, then he does not have to make this transfer at all. But what does the trustee get when the property is transferred to him? He gets only legal ownership because beneficial ownership is with the beneficiary. Therefore, when a settler appoints himself as the sole trustee, he surrenders the beneficial ownership of the property in favor of the beneficiary, but continues to retain the legal ownership of the property. Therefore, a settler can be the trustee. In fact, there are two questions rolled into one. Can a settler be a trustee? Can the settler be the trustee? That is, can there be some commonality between the settlers and the trustee? And can there be identity between the settlers and trustee? Answer to both questions is yes. When a sole settler is a sole trustee, all he does is he deprives himself of the beneficial interest in the property which goes to the beneficiary while retaining the legal ownership. If the settler and trustee are different people, the settler loses the legal ownership too. The next question is, can a settler be a beneficiary? And so therefore, again, two questions. Can there be some commonality between the settler and the beneficiary? And can there be identity between the settler and the beneficiary? Again, the answer is yes. A settler can certainly settle property upon trust for himself. Now here what happens, the settler, the settler as a beneficiary enjoys the beneficial interest in the property, but since he is not a trustee, he is surrendering the legal ownership of the property. In such a situation, there is a divestiture of legal ownership of the property in the settler. He gives up the legal ownership but retains the beneficial ownership. This actually, in practice also, it can have some application. Because, for example, if you are apprehensive of some mental illness or some other such incapacity, and you have somebody in your family you trust, let's say you have only one residential house, it may make sense for you to transfer legal ownership in that residential house to a husband or to a brother or to a child or somebody you trust. And by settling it upon trust, and the terms of the trust must say that you are entitled to occupation and its use throughout your life. In such a situation, this is actually a practical claim, particularly where the estate is very large, where the families are prone to disputes, etc. And in such situations, the settler divests himself of the legal ownership of the property while retaining the beneficial interest. On this point, there is actually case law. There is a decision of the Gujarat High Court in Bhavna Nalinkant Nanavati. Bhavna Nalinkant Nanavati reported in 174 CTR 152. That is 174 CTR 152. This judgment of the Gujarat High Court has been followed very recently by an order of the Income Tax Appellate Tribunal on the 27th of May 2020 in Escorts Benefit and Welfare Trust. Escorts Benefit and Welfare Trust. It is an order of the Delhi bench of the tribunal dated the 27th of May 2020. The tribunal judgment doesn't really improve upon the law. It simply accepts this position. The last question, therefore, is can a trustee be a beneficiary? We have dealt with settlor being trustee and settlor being beneficiary. Can a trustee be a beneficiary? Here again, two questions. Can there be a commonality between the trustee and the beneficiary? And can there be identity between the trustee and the beneficiary? Can there be commonality between the trustee and beneficiary? Absolutely. This happens very regularly. In fact, in a sense, every charitable trust, there is commonality between trustee and beneficiary because the beneficiary is members of the general public and the trustees are members of the general public. In a private trust too, there is no bar on this. But can there be identity between the trustee and the beneficiaries? The answer is no. If you have one trustee and the same person is the sole beneficiary, it cannot happen. If you have three trustees and they are also the same three people are the beneficiaries who are holding beneficial interest in the same pattern, it cannot happen. The reason for this is simple. Again, we must go back to Salmon. Ultimately, a trust exists in the separation of legal ownership and beneficial ownership. If the trustees and the beneficiaries are the same people, legal ownership and beneficial ownership comes back together and the trust ceases to exist. So to answer all these questions, can the trustee be a settlor? Yes. Can a settlor be a beneficiary? Yes. Can a trustee be a beneficiary? Yes, but the trustee and the beneficiary cannot be identical or exactly the same. Creation of private trusts. Section 6 is the provision of the Indian Trust Act which deals with the creation of private trusts. It contemplates 4 reasonable certainties. There must be reasonable certainty of intention to create, reasonable certainty, intention to create the trust, reasonable certainty in the purpose of the trust, reasonable certainty of the beneficiary, and reasonable certainty of the trust property. If there is no reasonable certainty of the trust property, then there is no trust, because if you're not clear as to which property you're transferring, the law will not read a trust in any manner. The other 3 reasonable certainties are somewhat negotiable. You may settle property upon trust and name the beneficiary later. Until then, nothing will happen. Similarly, you can settle property upon trust, name the trustee beneficiary, but name the objects later. So reasonable certainty of beneficiary, you need certainty in respect of some beneficiaries, even if not all beneficiaries. Reasonable certainty of intention to create a trust. This reasonable certainty in the last, say, 100 years has become mandatory. Before that, the British courts used to recognize what are known as precatory trusts. A precatory trust is where the settler merely exhibits a wish or a desire to create a trust, but doesn't actually create a trust. In those cases, the courts of equity used to hold that we must give equitable relief and say that trust exists. But that relief these days, that view is not taken. So reasonable certainty of intention to create must be clear. Therefore, in drafting the trust deed, there must be an unequivocal expression of all these things. Of course, that is beyond my syllabus. It will be dealt with a little later. The next point is transfer as a precondition for the creation of trusts. Now, we have seen that a settler transfers his ownership of the property in favor of the trustee so as to create a trust. What then happens if the settler is himself the trustee? Is there no requirement of transfer in that case? The answer is no. Section 6 itself says that transfer is a precondition for the creation of trusts in all cases except 2. The first case is where the settler is himself a trustee, and the second case is where the trust is settled by a will. As I pointed out, a will is not a transfer because it takes place upon the death of the testator, and therefore there is no transfer there. So section 6 says that transfer is not required where the settler is himself the trustee or where the trust is executed by a will. This principle has been upheld in the case on your screen, Tulsidas Kilachand, 42 ITR 1. Finally, requirement of registration. We are all familiar with Section 54 of the Transfer of Property Act, which says that if immovable property of the value of greater than 100 rupees is transferred, it will have to be registered. Section 5 of the Trusts Act says that if any trust is executed in relation to immovable property, then it will have to be registered. Here, that 100 rupee leeway is not there, which anyway in today's world is not material. So if your trust is a trust for immovable property, it requires registration. If your trust is not a trust for immovable property, it does not require registration. But this registration is one of the most misunderstood laws. What is being registered is not an entity or a person or a phenomenon or an action. What is being registered is merely a document. Section 16, 17, 18 of the Indian Registration Act 1908 must be mandatory reading. You will see that what requires registration is only the instrument of transfer in the case of immovable property or the instrument of trust in the case of a trust deed. Therefore, people will, this contention that a trust is a person because it is registered is very far from the truth, because a trust is not registered, only the instrument of trust is registered. Trust is created. What happens to the trust at the end of its life? Do trusts have lives with finite lives at all? I would love for that to be a metaphysical or philosophical. The end of a trust's life is described by the Trusts Act as extinction. This extinction of a trust occurs in two modes. The first is extinguishment of a trust, and the second is a revocation of the trust. Extinguishment, which is governed by Section 77, arises in a few cases. The first is where the purpose of the trust is fulfilled. The second is where the purpose of the trust is frustrated. That is, either it becomes impracticable or impossible to execute the purpose of the trust because the trust property doesn't exist or for any other reason, or the purpose of the trust itself becomes unlawful. Then the trust will be extinguished. These are the two situations of extinguishment of the trust. The next is revocation. Revocation again is an act which involves the volition of the settlor. We all know, if particularly senior chartered accountants, when I say senior chartered accountants, I'm certainly not one of those, will be aware of revocable and irrevocable trusts, which are a big source of dispute in income tax, because the clubbing provisions and all that will apply differently. So if a trust if the instrument of trust permits the settlor to revoke the trust may be revoked. Simultaneously, if a trust is created by a will, the will creating the trust may be revoked. This Section 78 very clearly says that a trust created by a will may be revoked at any time. Remember at this stage that this does not contradict the finding of the Supreme Court in Shivnath Prasad versus State of West Bengal, which we dealt with earlier, because that is a case where a trust was implied as between the two legatees after the hypothetical death of the settlor. We are dealing with a case where a trust is revoked by a will, where a trust is created by a will and revoked during the lifetime of one of the testators. If it is revoked by one of two joint testators, then the Seth Shiv Prasad principle will still continue to apply, and that does not contradict this. Let me be a little clearer. A trust created by a will may be revoked. If such revocation is in violation of a joint will, then the Supreme Court judgment would apply to hold that a constructive trust will arise after the death of the both of the testators. But this power of revocation of a trust by will itself is not affected by that principle. Then you must remember that most powers in the hands of the trustees are always available with the consent of the beneficiaries. Therefore, if the beneficiaries who are all competent to contract grant their consent, most things trustees can do, even if the trustee does not specifically provide for it. One of that is revocation. Therefore, if all the beneficiaries are competent to contract and all of the beneficiaries consent, then the trust may be revoked even if the deed of trust or the instrument of trust does not say so. At this point, I'll pause. You see, there is a bit of a tangent I need to address. This is Section 78. Here it says if all beneficiaries are competent to contract and all of them grant their consent, then revocation is possible. In certain other sections, it says such beneficiaries are as are competent to contract may consent. Therefore, in those sections, if some beneficiaries are minors or not competent to contract, their consent is not required. But here, all the beneficiaries' consent is required. There is a third class of sections in which it says that where a beneficiary is not competent to give consent, the principal civil court may give consent on his behalf. So there is some disharmony between these provisions. But there is no need for these provisions to be harmonious. They don't affect each other. And secondly, it is a statute from 1882. So if we find any disharmony in it, it's probably our mistake because statutes in those days were drafted particularly well. So this is revocation. What happens upon extinction? You see, you would think that when the Trusts Act deals with the modes of extinction, it will also deal with the effect of extinction and say what happens when the trust gets extinct. Surprisingly, the Trusts Act is silent on this. So again, we have to fall back onto the common law. In the case of extinction, the property reverts to its original state as the property of the settlers. That is, the moment a trust becomes extinct, the beneficiary ceases to exist, the trustee ceases to exist, the property becomes the absolute property of the settler or the author of the trust who originally settled the trust. But Section 78 specifically says that this will not affect what the trustees have already done before the extinction or revocation of the trust duly in accordance with the trust. So the author cannot be, so if the trustee does something in does some valid act under the trust, the author tomorrow cannot say, I don't approve of that, so I'm revoking the trust to undo what you did. That is not possible. So long as the act is valid, a revocation cannot affect that. Now, these are the duties duties and liabilities of the trustees. There is a duty to execute the trust. This is fairly obvious. As a means of, I suppose, some relief from the heavy subject, let me quickly deal with this word execute. Very many people are confused by this word execute because it has two meanings in the law. One is authenticating a document, signing a document is called execution. At the same time, doing something is also called execution. So most often when the law refers to execution, it refers only to the second meaning. Therefore, if it refers to execution of a contract, it means performance of the obligations under the contract. If it refers to execution of a will, it means giving effect to the will after the death of the testator by the executor. In fact, when I draft wills, there is invariably a provision appointing an executor. Some of these testators who sign the wills get a little shocked when they see the word execute in the context of death, because that has a third, rather more scandalous connotation. So the duty of the trustee to execute a trust lies in his duty to perform his obligations under the instrument of the trust. Again, even this provision, that is section 11, states that the beneficiaries may grant their consent to modify these duties or to excuse the trustee from performing these duties. As I was saying, this section 11 says that the consent of all beneficiaries being competent to contract is required. This is actually a slightly ambiguous expression. If it had said consent of beneficiaries being competent to contract, then you could have read it as consent of such beneficiaries as are competent to contract. But it says consent of all beneficiaries being competent to contract. Therefore, you can also read it as saying this entire consent can only be granted where all the beneficiaries are in fact competent to contract. So there is some problem here, but let this not detain us too long. Secondly, he must inform himself of the state of the trust property. This is a very important duty, and I think in practice also as consultants and advisors, this is something we must advise trustees on. This is particularly relevant when a trustee is appointed in a pre-existing trust to replace an earlier trustee. It is a very important part of the duty of a trustee to inform himself of the nature and circumstances of the trust property. If the property does not stand in his name, then obtain transfer to his name because he is the legal owner, and also ensure where the properties are invested, whether any of the properties are in risky investments and all that. The reason for this is if you look at section 23 of the Trust Act, which deals with civil liability for the breach of trust, the failure to do this, to perform this duty, itself constitutes a breach of trust. It is true that a trustee is not ipso facto liable for acts done by predecessor trustees. However, if the trustee upon attaining office does not, upon entering upon office, does not exercise due diligence to ensure that the predecessor trustee has fully discharged his duties, then by failure to exercise such due diligence, he will be committing breach of trust himself. Then he must protect title to the trust property. This is fairly obvious. As a legal owner, this in fact is his principal obligation. And the fact that this duty exists in his hands is proof of the proposition that the trustee is the legal owner. As an extension of this, it is also obvious that he cannot set up any title which is adverse to the title of the beneficiary. Ultimately, the trust property is held for the benefit of the beneficiary, and the trustee cannot thereafter set up any title. Trustee cannot set up any title which is adverse to the title of the beneficiary. Shri Vasudeva Narasimhan has raised one point. He says an oral trust of movable assets can be created and continue indefinitely as long as the author and trustee are clear. That is absolutely correct. I omitted to mention it. Section 5 of the Trusts Act makes registration a requirement only when the trust is in relation to immovable property. Oh, I think I mentioned it. It is in relation to immovable property. If the trust is for movable property, there is no legal requirement to register whatsoever. He is right. Then he next asks a question, will the same hold good also for immovable property? So let me read the section to you. The section is very clear. In fact, section 5 contains 2 paragraphs. The first paragraph is titled Trust for Immovable Property. It says, no trust in relation to immovable property is valid unless declared by a non-testamentary instrument in writing, signed by the author of the trust or the trustee and registered, or by the will of the author of the trust or of the trustee. Therefore, registration is required for a trust of immovable property except if it is by a will. Then the second paragraph, trust of movable property. No trust in relation to movable property is valid unless declared as aforesaid, or unless the ownership of the property is transferred to the trustee. Therefore, in respect of movable property, you have 2 options. Either you can execute a registered trust deed, or you can transfer ownership of the property to the trustee. And in the case of movable property, ownership is transferred by possession. So legally, movable property trust deed does not require registration, but strategically, it is absolutely essential. I would never recommend that you execute any kind of trust deed which is not registered. As a matter of practice, I also advise that, see, in case of charitable trusts, typically, it's not always that immovable property is settled upon charitable trusts. Very often, a token sum of 1,000 rupees or 5,000 rupees is treated as the property of the trust. And in such a situation, strictly does not require registration, but still registration is better. You see, tomorrow if you're asked to evidence something in relation to the trust, like the powers of the trustees, if the document is not registered, it becomes that much harder for any authorities to rely on. Coming back, so the trustee cannot set up adverse title. Then there is a duty of care. Now, this is a very dangerous provision because it's a sort of omnibus umbrella provision which deals with everything. It stipulates that the care that is required from the trustee is the care that a man of ordinary prudence will exercise in respect of his own property. This man of ordinary prudence is the ordinary man of commerce. These are 2 terms you find very often in all kinds of laws. I am very certain that no such man exists, but he is after all a theoretical conception. So you are as a trustee, you are expected to exercise reasonable care as will be exercised by a man of ordinary commerce. Now, what is this reasonable care? There's a lot of interpretational scope, but anything that fundamentally shocks your conscience is certainly unreasonable. But these days, the consciences themselves are arranged around a wide spectrum, so it is better to be careful. Fortunately, the draftsman have given us as many as, I think, 8 illustrations in this section. So any study of that illustration will make things clear. One illustration G is relevant. It says that A bequeaths money to B and C as trustees. That is, A is the settlor, B and C are trustees. These trust monies are placed in a firm in which A was a partner. Therefore, the trustees placed the trust money in a partnership in which the settler was a partner. The firm was reconstituted and the settler retired. The illustration says that at this stage, the trustee does not withdraw the property from that firm. He is not exercising duty of care, and this will in fact be liable for breach of trust. So this section is a little more dangerous than you think it is. Please read the illustration thoroughly. Then prevention of waste. The question is, there is already a duty of care set up by section 15. Why is then prevention of waste dealt with separately in section 18? There is a reason for this. We dealt with a case where there are multiple beneficiaries who take in succession one after the other. In such situations, the earlier of the beneficiaries must not be permitted to waste the property to the detriment of the subsequent beneficiaries. Duty of care is to be exercised by the trustee in respect of the world at large, not the beneficiaries. This prevention of waste is a duty to be exercised against one of the predecessor beneficiaries to protect the interest of the successor beneficiary. So prevention of waste is a duty against the beneficiary. Duty of care is a duty against the world at large. When we see the words perishable property these days, because of our background in tax laws, we tend to think about customs, seizure and confiscation of property, and therefore we think about food items, milk products. But interestingly, the perishable property as used in section 16 refers to any property of a wasting nature, including future or reversionary interest. Therefore, if there is an annuity of some sort where you end up losing money or the property itself will get depleted, then it is the duty of the trustee under section 16 to convert this property into some means which is not perishable. So this perishable is not physically or biologically or chemically perishable. Not only that, it is also something that is perishable conceptually. Then duty of investment. Until 17th of April 2000, until the 16th of April 2017, there were a list of investments given in section 20, and you could only invest the funds in those avenues. The law was amended after that to provide that the investment may be in any mode specified in the instrument of trust or any mode prescribed by the government. This is an amendment that is much needed, but the amendment has been carried out in a very lazy manner because there are various other sections, for example, section 41, which continue to bear reference to the old section 20 and have not been correspondingly amended. But suffice it to state that now, if the instrument of trust says that you can invest in something, you can invest in something. Please ensure, therefore, that the deed is also drafted properly. In fact, old trusts, it may be necessary now to carry out amendments if the power of amendment is reserved, because we will have to, that is a point which requires consideration. Then impartiality, as this is impartiality as between beneficiaries. It is one of the duties of the beneficiary not to be trustee, not to be partial to any of the beneficiaries. Then accounts and information, all this is pretty standard. Now, direction to sell within a specific time. Very often, at least in England, I don't think this happens too much in India. Properties are settled upon trust with a direction to sell the property, say within 6 months. The trustee is unable to sell it within 6 months, he sells it within 9 months. This section provides that the sale within the extended period of time is not void merely because it was not carried out within the period of time prescribed by the instrument of trust. All it says is if the trustee is able to prove that the beneficiary was not prejudiced by this extension, then no harm, no foul, the sale is not invalid. The last point is significant. If I am a trustee who has committed a breach of trust. And I have the trust property has suffered a loss of 100 rupees. Let's say I've committed a second breach of trust and the trust property has gained from that breach by 30 rupees. Let's say this breach was, I invested in equity shares when I was not permitted to do that by the trustee. So one investment in equity shares led to a loss of 100 rupees. One second investment led to a gain of 30 rupees. The question is, if the beneficiary sues me for the loss, will I be able to claim that I am liable to compensate him only to the extent of 70 rupees? That is the net gain and net loss arising from the two breaches. The answer is no. This is exactly what section 24 does. What it says, I mean, the reasoning underlying this is fundamentally you have breached and you are being held liable for the breach. You cannot therefore take advantage of another breach and claim that the gain from that breach must be set off against this breach. Now, therefore, in a proceeding, I as a trustee, defaulting trustee, will have to make good the whole loss of 100 rupees and not merely the net loss of 30. However, the words of this section must be understood very carefully. Where there is one breach which has resulted in multiple losses and gains, the net loss from that may be compensated. However, when there are two breaches, you cannot net it off across two breaches. So when there are multiple breaches, set off is not permissible. But when there is a single breach with multiple transactions, set off is obviously permissible. This brings us to the next aspect, which is the relationship of the trustees inter se. Is a trustee liable for a predecessor trustee's default? I have already touched upon this.
Mr. Bharadwaj, you take questions at the end or how exactly?
Are questions already available, sir? In the sense that I only received
some of the questions available with me. I received a mail from them. So I think maybe after this we can.
Yes, sir. I'll take 10 more minutes and then you can put the question.
Okay, done. Thank
you. Section 25 says that the predecessor is not ipso facto liable for a trustee is not ipso facto liable for his predecessor's default. But if he does not exercise his duty of care and he does not familiarize himself with the nature and the circumstances of the trust property, he may still be liable. In fact, the duties of a trustee upon taking office are rather onerous. They are not set out in the Act anywhere, but equity imposes various responsibilities on him. So far as co-trustees are concerned, again, the reasoning is the same. He's not automatically ipso facto liable for the default of a co-trustee, but he is liable if he delivered the property to the co-trustee and did not see to its proper application. He did not, exercise due diligence in conducting inquiries into the manner in which the co-trustee dealt with the property, or he actively conceals any breach committed by the co-trustee. He does not take steps to protect the interests of the co-trustees acts in reasonable time after learning of the breach. In these special circumstances, he will be liable for the co-trustees breach, otherwise he will not. Several liability, this is very important. If co-trustees jointly commit a breach, or where one co-trustee enables or permits by neglect another to commit a breach, they are not only jointly liable, they are all severally liable. That is, the whole of the liability can be recovered from each one of them. Once this is done, between them, contributions can be made based on the extent of the guilt. Of course, this only arises where there is a breach where there is a joint breach or more than one co-trustee participates in the breach. Otherwise, this several liability, there is no question of it arising. Where a beneficiary transfers his own beneficial interest to somebody else and a trustee makes the payment to the old transferor beneficiary, then he will not be liable for any loss resulting therefrom. There is also an indemnity to a trustee, which is that his liability is limited only to the property actually received by him. Now, breach of trust. This breach of trust means that the trustee has not fulfilled any obligation under the trust deed. This may be something as small as not getting the accounts audited, or something as substantial as misappropriating the trust property. The liability for breach of trust are of two forms. The first is civil liability under Section 23 of the Trusts Act, and criminal liability under Sections 405 to 409 of the Indian Penal Code. Under the Trusts Act, the trustee is basically liable for any breach of trust if it results in any loss either to the beneficiary or to the trust property. Of course, the exception is that if the beneficiary has induced the trustee to commit the breach, or the beneficiary has concurred in the breach, or the beneficiary has subsequently acquiesced in the breach. In these cases, the trustee will not be liable, but in every other case, the trustee will be liable. He will be liable for the loss caused by the breach. He will not ordinarily be liable for interest thereon, but Section 23 contains detailed rules as to when he will be liable for interest and how much interest he will be liable for. In some cases, it is 6% simple interest. In some cases, it is 6% compound interest. Then criminal liability. Criminal liability extends to cases beyond strict English trusts. There are certain situations in which you are not a trustee in the full sense of the term under the Trusts Act. For example, an executor of a will, he does not have ownership of the estate. However, he has dominion or he has some kind of power over the estate of the deceased. Even this kind of relationship will, if there are any obligations which are not fulfilled, will constitute a breach for the purposes of criminal liability on account of criminal breach of trust. Let me just read Section 405, which is the best way to understand any offense. Whoever, being in any manner entrusted with property or with dominion over property. Therefore, if he is entrusted with property, then he is the owner of the property. This is a normal trust. If he is entrusted with dominion over the property, he is not an owner, but he enjoys dominion. So these are other relationships which resemble the relationship of a trust. Where such a person dishonestly misappropriates or converts to his own use that property, or he uses that property dishonestly in violation of the law or any contract, then he commits breach of trust. In the general provision, the punishment is 3 years imprisonment along with fine or fine or both. In certain special circumstances like breach of trust by a servant, breach of trust by a civil servant, the punishment is a little more. As I pointed out a little earlier, these are the disabilities of trustees. As I pointed out a little earlier, once the trustee has accepted trusteeship, he cannot subsequently renounce, except if he approaches the court for discharge as a trustee. A trustee cannot also delegate. That is, if a certain power is given to a trustee, he must necessarily perform that power, exercise that power himself. This is subject to reasonable exceptions. For example, in the ordinary course of business, he may delegate. If the beneficiary consents, of course, he can delegate. If the instrument of trust provides, he can delegate. To illustrate, this delegation requirement cannot, this bar on delegation cannot be read absolutely so as to say that a trustee cannot even get his office boy to go and buy a pen to write something relating to the functions of the trust. So reasonable delegation is possible. But overall, there is a bar on delegation we must be very conscious of. There is a decision of the Supreme Court in Janaki Ram versus Neelakantha, AIR 1962 SC 633. In that case, a trust was settled under which the trustees were required to sell property at the best price and thereafter pay the creditors out of the sale proceeds of the property. What the trustees did is that they sold the property and directed the purchasers to pay the creditors. The Supreme Court held that this amounts to an impermissible delegation and held that agreement between the trustee and the purchasers to be void, at least to this extent. If you say that a trustee cannot delegate, and then there are 5 co-trustees, then if these 5 co-trustees, unless the trust deed says something else, the 5 co-trustees must necessarily act jointly. There is no question of majority, there is no question of a veto power or anything like that, unless the trust deed specifically says it. If the trust deed is silent on the manner in which co-trustees must execute their functions, then they must all act jointly in all matters. In fact, this is actually an extension of that principle of delegation. Because if principle against delegation, if co-trustees have been named, the author has named them in the sanguine expectation that they will act together and not that they will act independently. If he wanted them to act independently, he ought to have said as much in the instrument of trust. On this point, the Supreme Court has upheld this proposition in Shanti Vijay and Co. versus Princess Fatima Fauzia, 1979 for SCC 602. 1979 for SCC 602. Trustees are not ordinarily entitled to remuneration unless the instrument of trust provides. They are, however, entitled to reimbursement of expenses. And there are various other duties which I won't go into in detail. Oh, I'm sorry. Mr. Shri Gurudatta Devaya has asked a question. Suppose there is a private trust executed where it is mentioned that the trust is established for the purpose of benefit of minor child of the settler. In such a case, for the purpose of income tax, can the income and expenditure be accumulated till the date of all beneficiaries becomes major or not? This is a subject of income tax which will be dealt with on 4th by Sri Sangvi. It will not be appropriate for me to encroach upon their territory. And it's not strictly with the subject. I'm sure, sir, that the question will be answered on the 11th. Then we come to the rights of the trustees. He has a right to the title deed of trust property. He has a right to reimbursement of expenses. If he commits a breach of trust and some third party gains from that breach of trust, then the trustee has a right to be indemnified to the extent of that gain. The right to the opinion of the court is a very significant right contained in section 34 of the Indian Trusts Act. It stipulates that without instituting a suit, the trustee may seek the opinion, advice, or direction of a civil court by means of a petition in respect of any present questions respecting the management or administration of the trust property, other than questions of detail, difficulty, or importance. Next, I will spend a little bit of time on this. What is contemplated here is the opinion, advice, or direction. There is some confusion even amongst case law as to whether this opinion, advice, and direction, even if the court grants it, will it be binding on the trustee? Some cases have held that these directions are not binding. These conclusions of the court are not binding. Some cases have held that they are binding. Some cases have held that if you violate them, there is no contempt. Some cases have held that if you violate them, there is contempt. But in any case, in my view, there are three phrases: opinion, advice, and direction. Opinion and advice may not be binding, but the direction will be binding. Therefore, if you approach the court, it is necessary to seek relief and draft the pleadings very carefully to ensure that what you want only comes. And the power of the court here is reasonably wide. On any question concerning the administration of the trust, the trustee can go to the court. So typically, this can be used as a protective measure for the trustee, where there is some conflict between the settler and the beneficiaries or between beneficiaries inter se, then to ensure that he is saved from liability or he is saved from the wrath of the beneficiaries of the settler, he can go to the court and seek opinion and advice and say, listen, I'm just following what the court told me to do. Trustee has a general power to do anything necessary for the administration of the trust. In respect of trust for minors alone, the trustee has the power to pay monies to the guardians or to otherwise apply the income of the trust towards the maintenance or education or the advancement in life of the minor beneficiary. He is also empowered to apply the income of the trust for reasonable expenses of religious worship, marriage, or funeral. All this is only in respect of income. If he wants to apply the property of the trust, then he needs the permission of the civil court. That is, if 10 lakhs has been settled on a trust on FD and interest is being earned, he may apply that interest for all these purposes without the permission of the court. But if he wants to liquidate that FD itself, then he will have to seek the permission of the court. I think my time is up. What I will do is, at this stage, I will take questions and then I will hand it over to my father for dealing with the other subject. I will come back. There is not much left other than the vacation of the trustees' offices, a position of beneficiaries. I will deal with it when I have time. if sir, the questions you may put now.
Yeah. So there are 3-4 questions from
Yes, sir.
Chandrahasa.
Yes, sir.
Is there any restriction on a male Hindu in creating trust and handing over all assets and income to the trust? Can trust be mandated to maintain unmarried sisters, widow, sister-in-law, dependent parents, and children?
There is no responsibility to maintain wife under Hindu law. Sir, there is no bar. So you see, the difficulty here is that there is a confusion between the Hindu personal law and the statutory law on the same subject. If where there is a statutory provision permitting something, it necessarily overrides the pre-existing principles of common law or the principles of the personal law. So there is no restriction on a male Hindu creating trust and handing over all assets and income to the trust. The only thing you'll have to note in this context is if any of this property is co-parcenary property, HUF property, then there may be an issue. But if it is the separate property of a Hindu, he can create a trust even in favor of some unrelated third party.
Can he ignore his widow and other dependents?
No, before we go to that, there's one point.
You have
Yeah. You are on mute, sir.
Oh,
Sheshadri,
sorry.
sir.
Yeah, before we go to the other part of the question which is raised, you should take care of section 56. Section 56 proviso, I think Roman 10, exempts only those cases where the transfer is made by an individual to a private trust and the trust is solely for the benefit of his relative. Relative as defined in subsection Roman small 7 of section 56(2). So that aspect may prevent you from giving it to various individuals who may not be relatives within the definition, and third parties in particular.
Yeah, that's
so there is no bar on that.
Okay. Other than tax, there is no bar, so he can give.
In fact, so far as the question of tax is concerned, in the explanation to clause 7 of subsection 2 of section 56, you will only have to tick off and see whether each of these people are relatives there.
Yeah, relatives,
if they are relatives, there is no problem.
Another controversy in section 56(2)(7) is whether
dual flow, both sides, whether it will be treated as relative is a point which is to be confirmed. In this particular case of trust, there may not be an issue. But 56(2)(7) in general, the definition of relative, please be careful.
Okay. The point being made is if X is Y's relative, it does not automatically mean that Y is X's relative. So you will have to apply the definition each time.
There was a beautiful article in the ITR.
In Jignesha, that's an article which we must read, because this is very similar to the provision in the Old Companies Act in 1956 Act, where one side relative was accepted and the other side relative was not treated as relative at all. So,
yes. Yeah, second question from Chandrasa is, when purpose of the trust is fulfilled, say minor attaining majority, should the closure of the trust be recorded with the sub-registrar? What formalities to be followed to record closure of trust?
Once the purpose of the trust is fulfilled, by the operation of the law, the trust becomes extinguished. That is, I think, under section 77 of the Indian Trust Act. When the law itself says that something is happening, there is nothing that you need to do any further. There is no legal requirement that you have to notify the sub-registrar. You must remember that the sub-registrar is an authority under the Indian Registration Act. His function is only to register whatever document is given. Under section 17 of the Registration Act, you can register any document. If somebody writes a love letter and he wants to register it, he may very well go and the registrar is duty bound to register it. So therefore, there is no legal requirement. However, you must evaluate strategically what are the competing interests at that stage. Will there be any dispute? Or will some other third party cause a problem? In these cases, one very, very efficient instrument of protecting people is affidavits. If you want somebody to say, listen, I have attained majority, I am no longer entitled to any of the benefits under trust, and I have no further interest. Let the beneficiary execute an affidavit like that, so that tomorrow he cannot come and say, no, this was not what was understood.
In the context of documentation, We had a trust which had actually, there was a huge immovable property which was based in Bangalore. And there were 3 individuals, beneficiaries, that is the mother and the 2 children. Now, when it had to be wound down, we had to pay the stamp duty for transfer of the property from the trust to the three individuals, 1/3 each. And subsequently, they sold it and went through the capital gains provisions and gained the exemption under Section 54. There was no possibility of avoiding the stamp duty. So stamp duty provisions are to be looked at. One point which I would always tell you with respect to the Trust Act and trust law is that it is to be read along with the Transfer of Property Act, the Registration Act, and the Income Tax Act before you take any decision and before you advise. So this is actually one of the reasons for the complexity of the entire arrangement. And in the context of affidavit and so on, there was a very interesting case before the Bangalore Tribunal. There was a hiba, that is an oral gift, which was claimed by the individual for the penalty which was levied. Because there was some other document which said that a particular property was the lady's, and so the net result was 54F she was not eligible for. Ultimately, the hiba was actually justified through an affidavit which was notarized. So although oral gifts are accepted under this Muslim law, the point is there has to be a document ultimately to say that the transaction actually took place at that point in time. So an affidavit was made available, and that was the basis on which the tribunal let her off with a penalty. So there has to be documentation, there has to be registration, irrespective of what is the strict legal requirements of the law.
Yes, sir. The next question. Are a Hindu male aged around 70 years, unmarried, only son of deceased parents Mr. and Mrs. P. His intention is to leave everything to charity after his death. Which option is advisable, to give away through will or to create a trust and mandate that trust to fulfill his wish to give away to charity? Can R leave everything to charity? If R has dependent brother, still can he give everything to charity, ignoring his brother? You want me to repeat, sir?
No, sir, I have it on my screen actually.
Yeah, okay, fine.
I'm cheating and letting you read because I've spoken for an hour. My voice is a little tired.
Yeah,
sir.
that's good.
If you have
Actually,
a
see,
problem,
other
I will
people
read
also
it.
will listen that. That is the reason I am reading.
No
Okay.
problem. If you want, I will read it, sir.
No issue.
So, whether he can bequeath the whole of his property to charity despite having dependent relatives, the answer is yes. The freedom to deal with one's property by wills is almost absolute. If provided it is a separate property, it is not HUF property, there is no restriction, you can do it. Which option is advisable, whether to use a will or the trust? Sir, after having spoken on private trust for an hour and a half, let me tell you that there are very narrow classes of cases in which we will actually advise a private trust. When you have your own property and you're willing to execute a will is 100% the better option. A trust only creates complications. You'll have to name a trustee tomorrow. The trustee will not want to execute the trust. He will be cursing him, saying, you see, in his old age, he has made me do something. I could not say no. Therefore, I'm doing it. So a trust is not a good option for this situation. So the answers are yes, he can leave everything to charity, and I would recommend a will, but there is nothing mandatory. So wills executed by people other than members of the armed forces in battle are called unprivileged wills. The only requirement for an unprivileged will is that it should be executed in writing and it should have 2 witnesses. Will does not require to be stamped or registered. However, as a matter of routine, we recommend that every will be registered. The moment there is property, somebody will come and produce a fake will tomorrow. Somebody will say that this will is fake and you will be stuck in litigation for years later. So please get a will registered. And of course, depending on the state in which you reside or the property is, you may have to secure a probate from the probate.
Okay. Okay. Suppose his question continues. R has dependent brother. Still can he give everything to charity, ignoring his brother? It is self-acquired property.
Absolutely. Let me put it another way. The law does not impose any obligation of nobility. So you can be a terrible person and the law will permit it.
Okay. The fourth question.
1 second.
I have a point.
Yes, sir.
I had a case of a person who wanted to will all his properties, mainly for charity and some to his employees, to the exclusion of his own wife and daughter. So these are acceptable practices which go on, because otherwise the successors are well endowed and they have sufficient income and money. So you may want to give it to charity. In fact, there are some reported decisions, one of which we will discuss sometime later. In that particular case, the clear arrangement was that after the two beneficiaries enjoy the property has to go to charity. So it's a very normal process which goes on, and I don't think there should be a problem.
Okay,
I will just make one point, sir. Sorry.
Yeah.
All these questions come from a place of Hindu law, because even in fact Hindu law goes one step further. It contemplates what is known as a pious obligation. That is, the father has a liability. It is the son's pious obligation to repay that liability, and that was being enforced as law in India. The point is, if you look throughout my discussion on this trusts, the Indian Trusts Act is drafted by Britishers because it was in 1882. The common law on trusts, our legal history is not the Indian legal history. It is the British legal history. It has been imported from there. Therefore, you might find it somewhat repugnant to our social cultural ideals, but this is the law.
okay. The fourth question from him is Trust C. There are 3 beneficiaries, including one trustee as a beneficiary.
Absolutely
Two
no
non-trustee
problem.
beneficiaries decide to remove beneficiary cum trustee for reason of unfair conduct and bias in distribution of income. What is the procedure to be followed to remove him as a trustee?
Remove him as a trustee.
Yeah.
Oh, that which you will have to go to the civil court, sir. There is no
Civil code.
Yeah, but even that, whether you will succeed or not, is unclear. See,
Okay.
if you establish in proving that there was some kind of breach of trust or there was a violation of one of the duties of the trustees, then you can do it. Otherwise, you can't do it. But actually, the right. If you look at the rights of the beneficiaries, 1 second, let's just take you there. I didn't cover that for one time. They have certain very important rights which may sort of improve the position. See, this first right to transfer beneficial interest. If all the beneficiaries are major and they are competent to contract, and they are all none of them are married women, then none of them are married women, and the trust was not created by the husband. So if the trust was created, say, by a father, there are 3 brothers and sisters, all are major. They have they have a right to transfer the they have a right to proper trustees. Section 60 of the Indian Trust Act. So this right can be enforced in a civil court. Section 60. This is the remedy. You can approach a civil court under Section 34. There is no, and also you have a right to vary the terms of the trust under certain circumstances. If all of the beneficiaries come together, you will have to examine whether varying the terms of the trust would include changing the trustees. But you are not without remedies. Let me put it that way.
No, if settler gives that option, changing the trustee and all while he is settling, that is a good idea.
Sir, this is another. You are right, sir. Absolutely. When the trust deed is drafted, all this must be contemplated right in the beginning. In fact, since the property goes out of the hands of the settler, if that deed is not sufficiently protecting you, after that you are in real trouble. In fact, it is my opinion that even in the case of charitable trusts, if you have executed a trust deed, unless a trust deed has a power in it to amend the trust deed, you cannot even amend the trust deed.
Amend the trust.
So all these powers to protect yourself must be reserved. In appointment powers, rights of trustees, there will be a detailed section dealing with what all they can do, whether they can be changed, whether a majority of the trustees can act, whether if there are 5 trustees, by a vote of 4 on 5, one of the trustees can be removed. All this has to be provided. So see, you don't have. It's not as if in this question you are without a remedy, but it is not simple.
Yeah. As much as possible, better to cover in the trust deed itself. Exactly. Removal or appointment or amend, all those things.
Absolutely. Which is why the next 1.5 hours deals with that.
Yeah. Okay. Thank you very much. The last question from him again.
Sir.
What are general precautions to be followed in drafting trust deed to balance power of trustees and interest of beneficiaries? For example, delay in distribution, I think, which we discussed right now.
Yeah. So all these questions is what is the rest of today's seminar from 5:30, 5:45 onwards. You see, I always tell everybody that I'm a very young practitioner. So my knowledge is limited to the book. On these questions of what are precautions to be taken, that is not question of law, that is a question of strategy. Therefore, I am not entirely competent to answer those questions. Since there is a senior practitioner with us, he will deal with all of that.
One more question. When you
Yes, sir,
were
please.
talking,
Please, sir. Please.
so when in case of trust immovable property, the settler himself is the trustee.
Yes.
The transfer is not required. That's what I
Yes.
heard. Is
Yes,
that right?
Yes, sir. Yes.
So then how then once he is not there, he is no more, how
Yes.
that property moves to the next trustee and to the trust?
That is subject to the terms of the trust only, sir.
No, when we mention in the trust deed itself, there are this sub-registrar insist for the stamp duty.
Oh, is he insisting? But that's not.
Yeah.
No, but so if he is himself the trustee, so actually, sir, this is the difference between a deed of trust and a declaration of trust. A deed of trust arises when there's a transfer from a settler to a trustee. A declaration of trust is where he is himself saying, I am the trustee. There is no transfer happening, so he cannot insist on stamp duty. That is completely illegal. You have to challenge it in the appropriate methods. But your question on what to do when he dies, in such a situation, the transfer from him as a trustee to the next trustee, that is not a transfer, that is a transmission arising on death. It is a matter of succession. So even that cannot be liable to stamp duty. If that is the logic, then a will has to be stamped. So the
Then I think in majority of cases, this private trust, normally this settler is there. So can he do like that?
No, so in a majority
there are many immovable properties involved. He says that I myself the trustee, and after some time he retires and the new trustee comes. The transmission happens and property move on.
So two things, sir. Firstly, in a majority of the cases, it is never him as the sole trustee. If he is the sole settler and the sole trustee, this is the law. But if he is the sole settler and he and his friend are two trustees, then transfer takes place, stamp duty will be payable. The second point is on the question of retirement. Retirement, at that stage, there will be a transfer. If he dies, there is no transfer.
Okay, he dies, no transfer.
Yeah.
Retirement,
Yes.
it's a
See,
transfer.
I have to tell you one point. I have intervened at this stage. Under Section 4, I think defeating the provisions of law through the trust is illegal. So if you make a trust, so the proposal which was discussed a couple of minutes earlier actually attempts to make a transfer violating the stamp law. That is, I create a trust and then I'm the beneficiary and the settler. At one point in time, I go out, somebody else comes in. So you are basically defeating the provisions of law. And so the trust will be deemed as illegal. So you should be very cautious.
I'll interrupt, sir. In that case, it is not only the beneficiary. Beneficiaries are many other. Settler and the trustee is one and same.
Okay, so changing the trustees, that's okay.
Yeah.
I actually, with utmost respect, I disagree with this view. You see, when there are two transactions you contemplated, sir. One, in both transactions, the settler is the only trustee in the beginning. In one case, he dies. In one case, he retires. Where he dies, there is no transfer, there is no stamp duty. Where he retires, there is no violation of the stamp law. At the time of retirement, you have to pay stamp duty. At the time of creation of the trust, you need not pay. But when he retires and a new trustee comes, then you will have to pay anyway. Because then
when the beneficiaries are many, he is not only the beneficiary and trustee.
On this question of stamp duty, the beneficiaries are not relevant.
Not relevant.
What are many?
Not relevant. Okay. Thank you. I think we concluded that, sir. I think Sheshadri sir can take it forward.
I will just share the other screen.
Yes, sir.
Green I'll take. Green I'll take.
See, the limitations of wills, because will is normally considered as an option to a trust, and one is considered and pitted against the other to decide on which is a better option. Now, as far as wills are concerned, there are certain limitations. One is the litigation. You look at the famous Priyambada Birla's case. I think Bharadwaj discussed the case law involving Shivanath Prasad versus West Bengal in the Supreme Court. So that was one part of the litigation which went on. There have been other cases before the Supreme Court itself on the validity of the will and many other aspects. And especially in India, many wills are not registered, and this gives rise to further problems. Codicils are made amending the will. So there is always a possibility of litigation unless the will is registered and it's very clear. Second is a fragmentation of assets, where there is a large property base which is available with the owner. And if he has to divide it among the various beneficiaries or his successors, generally the assets tend to get fragmented, especially if it's a single business. So the trust is a better option to prevent this kind of a fragmentation. And that's why you find that many businessmen adopt this route also. Variations in market value. You have multiple properties belonging to an individual. One property is, say, in a very highly priced area. The other property is another area where the price is not big enough. And so the result is division could be not very fair among the successors, or the divisions may have to be partly in one property and partly in the other, which will have its own problems. So this kind of variations in market value is another limitation when you make out a will. Next is the wills can be revoked and changed. We had a very interesting case where there was a husband and wife, and they had a daughter, and they had nobody else. And the property was to go to the daughter. But in a moment of pique, there was some kind of an argument, and the man went ahead and made a conditional sale to a third party, another relative of his, depriving the daughter of the property. He revoked the will. So this kind of problems which arise out of certain cantankerousness of the owners can be a problem in the case of a will, and will can be changed at any time. You will find that wills which are made in favor of X and Y, a couple of years later, they would like to change it in favor of A and B. This creates uncertainty, especially in the minds of the genuine successors. And the next point is ring fencing of assets is not possible during the life of the testator. That is, when you have a property which belongs to an individual and it is only willed out, if tomorrow there is an impact of any personal guarantee given to a bank or an institution, that asset is not protected because the asset still belongs to the individual who has guaranteed the money. And so the bankers will be in a position to attach the property. This is one reason why during this period, you find that trusts are executed to ring fence the asset. The next issue is probate. Probate involves stamp duty and payment, especially if the properties are situated in the 4 metropolitan cities. And in certain situations, even in non-metropolitan areas, where there is an ambiguity, the buyer of the property may ask for a probate. So these are all problems as far as the wills are concerned. And probate goes through the court, and there is a stamp duty impact. That's a problem as far as the will is concerned. Now, the need for trust, one is the protection against insolvency, especially with the introduction of the IB code. Differently abled and incapacitated children and successors is a very serious issue facing the families now. Earlier, we had joint families. So when a child is incapacitated or disabled, the other members in the joint family, including the younger members, would participate and take care of the child. Whereas now with nuclear families, you normally leave the children to themselves, and in case of any disablement and incapacitation. In fact, there are some organizations which provide this kind of facility by having a trustee, allowing the father to build the property, and they take care of the child even after the death of the parent for as long as the child lives in their own house, and provides succor and comfort. So that is why, and that is possible only through the instrument of will. Protection of traditional family businesses. You have a business which has been going on for a long time, say through 2-3 generations, And at the end of the day, the fourth generation feels that they have to get into some other kind of a startup or a new venture, and they're not very comfortable with the business which has been carried on by their parents and grandparents. In such a case, a trust can be created, and if the business is made, business is available to the trustees to run, and as long as it is for the benefit of the close relatives, the trust would be running the traditional family business, and the income would be available to the beneficiaries who can either reinvest or use it for whatever purposes. The next category is, next point is disinterested successors to businesses. You normally have people, especially in the current age, where the children automatically do not take to the profession or to the business of the parents. So they normally would like to venture out, open out. You have cases where very successful lawyer's son becomes an automobile consultant, or a very successful CA. He is not interested in the CA profession at all, but he takes to music. In all those cases, trust will yield and also ensure sufficient income to the beneficiary. Ease of governance and low regulation. It's not governed by any specific law except the Trust Act. And it's also easy to govern. And no probate is required in the case of a trust. In the case of Muslims, due to the restrictions in personal law, trust is one of the means to ensure succession to their own people, their own children. When there is inheritance tax abroad, many of the property owners in India who also have interests abroad would prefer this kind of a arrangement to avoid the inheritance tax abroad. There is a perception that there are substantial tax benefits available to trusts in India, and that perception also sways the decision towards a trust. And control. Control is another very important aspect. That is, when you have a trust which runs the business or takes care of the properties, the control is in the hands of the trustees. And the trustees are normally the parents, uncles, and so on. And so they are in effective control of the property, and it doesn't get dissipated on account of litigation or any other reason. So between will and trust, these are the comparative advantages and disadvantages. The decision to choose one or the other will depend on the individual asset component, the nature of the owner, the nature of the beneficiaries, requirements of the owners, and requirements of the beneficiaries. So you will have to, and also the scale, the volume, which is very important in the decision. If the property is not substantial, if you have one or two properties, will might be a better option. But if you have a complex set of properties and different lying in different baskets, various immovable properties, tenanted and then untenanted, investments and so on, and children and grandchildren who have a share in it, trust might be an option to consider. Now, the types of trusts and forms. The first trust is discretionary trust by will. The advantage is that the stamp duty is avoided. No transfer, so there is no tax impact. And it's also taxed as an MOP under 164(1) Proviso 2, provided it's the only discretionary trust which is declared by the testator. So discretionary trusts of this nature, provided by the will, are a useful instrument in certain situations, even when it is running business, because 164(1)(2) says is an exception to the normal clause that MMR is to be charged. Revocable trust settler can revoke at any time, but the difficulty here is Section 61 of the Income Tax Act, which provides for clubbing, and transfer will be liable to tax. Discretionary trust, trustees can choose the beneficiaries to whom the benefit to accrue and quantum. This is a very desirable thing where you have children or successors who are entitled to, who necessarily have to receive different sums of money or larger sums of money at different points in time due to any special requirements. For example, medical treatment, education, or any other support. One of the children may not be well endowed or may not be very successful, and he may need to be given much more than what falls to his own share. In such cases, discretionary trust will be a useful instrument, although the tax problem will arise in the case of discretionary trust. Determinate trust, the entitlement of the beneficiaries is fixed by the settler or by a formula, and there is no discretion to the trustees at all. There is a very interesting case law which discusses this, that is P. Shaker Trust, Madras High Court. I suggest that you read it. I'll give you the It's actually 363 ITR 679. This case is very interesting. What really happened was only 10% of the income was to be distributed as per the shares which was specified in the trust deed. Now, the balance 90% had to be credited to a corpus to be made available to the beneficiaries only after the termination of the trust. The AO sought to tax the 90% amount under Section 164. Battery is running low. And the High Court said that it is a definite trust and Section 64 cannot be invoked. So the P. Shaker Trust 363 ITR 679 is a good read as far as what is a discretionary trust and what is a definite trust, because it's also peculiar facts of the case. Irrevocable trust will not end until the purpose is achieved or the term ends. So these are the various forms and types of trusts. Now, the most important document here is actually the trust deed. As far as the drafting of the trust deed goes, ensure that it's as detailed as it is in the case of an articles of association where there is a PE investor. You know, you have an exhaustive definition clause. You have a very exhaustive rights and responsibilities of the people. It should be as detailed as that. If you're able to get trust deeds of institutions where the institutions are the trustees, you will find that the trust deed is fairly detailed. What are the details to be contained there? One is, of course, the name and the detailed recitals. Recitals are very important. The settler's intention should be spelled out. There has to be an unequivocal declaration of the trust. There has to be a definitions clause. Every term has to be very clearly defined so that there is no ambiguity or dispute at a later point in time. The purpose and object is to be cleared. The term of the trust and the particulars of the trustees and choice of the trustees. These two issues are very important. If it's going to be a business trust, you may need somebody who has got commercial savvy and who is in a position to manage. If you have a basket of properties which are to be managed within a trust, you may require trustees with special capacities. You may require certain people who are experts in finance, certain others who are actually experts in certain aspects of business. Say, for example, a manufacturing industry. So you will have to decide on the nature of trustees based on the requirements of the beneficiaries, requirements of the property which is to be managed, and the other factors, your own capacity to trust the trustees. Now, as far as the trustees go, there are certain points. There are certain other points which are to be really mentioned. One is the names, mode of selection. Second is the retirement. And the next is resignation. Under Section 46 of the Indian Trust Act, the trustee should contain a provision. And if the trustee does not contain a provision, you will have to either approach the civil court or the consent of the beneficiaries would be needed. So when you draft a trustee, many of these points cannot be taken for granted. We cannot just provide for no clause for resignation on the assumption that these are all implied powers, as we understand in the case of the Companies Act, because there are specific requirements under the trust law, which is to be taken note of while drafting the trustee. Second is removal in case of any specific situations, replacement, and next is remuneration. In the case of remuneration, what really happens is under Section 50 of the Indian Trust Act, remuneration can be paid. No remuneration can be normally paid unless there is a provision in the trustee or the civil court gives consent or the beneficiary consent is obtained. Except in these situations, no remuneration can be paid to the trustees. The next is what happens in the case of incapacitation or insolvency of the trustees. This is a point which cannot be ignored. Normally, when we create a trust with the relatives as the trustees, and these relatives are basically senior members in the family. Now, at a certain point in time, you could have situations where they're incapacitated, or there is some other financial emergency which has taken place, which has resulted in insolvency. In such cases, what do you do with the trustees? These are to be provided for. Now, the choice of the trustee, as I've already made it clear, will depend on the commercial requirement, and also will depend on the family member. How close is he to the family? Is he a very trusted advisor? And how much the family wants to control the trust? Normally, in the trusts which are formed for the benefit of the families, the trustees are relatives. So you will normally presume that they will have the interest of the beneficiaries because they are their own relatives. But you could have situations where there are independent trustees, in which case these considerations will have to be taken note of. The neutrality and expertise of the trustees is very important. They have to be neutral between children, beneficiaries, and they have to have expertise in managing the legal aspects, taxation issues, the business interests, and so on. Next is age of the trustees. If they are old, there may be a replacement plan which is required, and that has to be taken note of. Now, the mechanism for decision making. Now, mechanism for decision making is normally you provide for voting and voting by a majority. But I would request you to see Section 48 of the Indian Trust Act. That says the core trustees cannot act singly, which basically means that the trustees will have to be unanimous in whatever decisions which they take. To avoid this particular contingency, provide for majority in the trustee so that there are no hitches later on in the day-to-day functioning. Now, you may have to provide for a casting vote or a veto. Veto in case of certain situations where there is a senior member who differs, or a casting vote where there is equal division. And so resolution of deadlock has to be provided for. In this particular context, one important point is the question of arbitration. Generally, as a matter of policy, as a matter of practice, all of us provide in the agreements that arbitration clause will apply under the Arbitration Conciliation Act. Very recently, there was a case before the Supreme Court, Vimal Kishore Shah versus Jayesh Shah. That is actually very unfortunately reported only in Manupatra. You will not get it in Taxman, but you may get it on a Google search. In this particular case, the Supreme Court has held that the arbitration clause will not apply to trusts, and only the civil courts have got jurisdiction, and legal remedies are available under the Indian Trust Act. In this particular case, what really happened was there were disputes between one set of families and the other who were beneficiaries. And that particular trust was actually set up for 6 minors, and 2 were managing trustees. Clause 20 of the trust deed provided for arbitration under the Indian Arbitration Act. So when the arbitration was required, arbitration basically requires under the Indian Arbitration Act, number 1, an agreement. Number 2, an agreement in writing, signature of all parties, and arbitration clause in the agreement. Now, one set of parties contended that one of the conditions that the signature of all parties is not met because I am only a beneficiary and I have not signed the trust deed at all. And I am not a party to the trust deed and I have not consented to arbitration. So this particular clause is not met. The matter went to the Supreme Court, and the Supreme Court basically said, Trust Act contains specific legal remedies through the civil code under various provisions, section 7, 11, 34, 36, 41, 45, and so on. And when these specific clauses are there for resolving any deadlock, arbitration cannot be a means, and arbitration was held to be inapplicable. Indian Trust Act provides remedies. In paragraph 58 of the judgment, this aspect is very clearly discussed, and civil court alone will have the jurisdiction. This judgment is very interesting to read because it also discusses in which situation arbitration will apply. For example, in a marital dispute, in certain personal disputes, arbitration cannot apply. So that particular decision, which actually covered that aspect, was also extracted and relied on while reaching this conclusion in this particular case. Now, how do you conduct a trust meeting? Trust meeting with the trustees, you will have to provide for a proper minutes book, how are the minutes to be maintained, whether the minutes are to be numbered, signed by the chairman or signed by all the trustees. All these issues, periodicity, the quorum, who will be the chairman if the chairman is not available at a given point in time, whether circular resolutions are permitted, decision by majority, unanimity, or casting vote, and then consequences if trustees are not regularly attending the meetings, allocation of responsibility and work among the trustees, appointment of employees for the trust. All these aspects will have to be provided for as far as the minutes is concerned. And accounting year and audit is very important, which all of us know in the context of charitability. powers of the trustees, make this as detailed as possible, as in the case of an articles of association. The powers of the trustee should cover investment, the power to borrow, the power to guarantee, power to acquire and sell fixed assets, power to lease out fixed assets, power on various other legal matters, compliances, including filing returns, filing petitions before the court, entering any caveat, and filing debt petitions, and various other litigations and various other comprehensions which are required even under the normal municipal law. So all these issues are to be covered, and it has to be a fairly detailed trustee. Now, delegation is a very important issue. You will normally need to delegate, but Section 47 of the Act says that no delegation is possible unless it is essential, or unless it is there in the deed, or unless it's in the regular course of business, or the beneficiary consents. Let's look at these conditions. Unless it is essential is actually a justiciable matter. It may have to be ultimately decided by the court, because I may say it is not essential, and the other beneficiary or the other trustee may say it is essential. If it is there in the trustee, the problem is sorted out. Now, if it's in the regular course of business, for example, you have to appoint a lawyer, or you have to appoint a chartered accountant. Obviously, that involves delegation, and that is permissible under Section 47. If the beneficiary consents, the beneficiary consent is actually a normal, what you could call as a default provision, which is available in many of the sections which we have discussed now. Now, so as far as delegation goes, there has to be a specific provision, and specific provision should be absolutely clear to provide in what situations they can delegate, to whom they can delegate, and so on. Next, we come to the beneficiaries. Define the beneficiaries. What is a share? At what point in time will the share be distributed? Now, if it is discretionary, then the power of the trustee is to distribute. If it is a definite trust, specific trust, then what should be the share of the beneficiaries? What's the beneficial interest? And consequences in the case of death of the beneficiaries. Alternate beneficiaries in case of death. Addition and removal of definite beneficiaries. All these are issues which are to be taken note of in the trustee. Trustee has to be basically flexible. You have to imagine what are all the contingencies that may arise, and based on that, process will have to be introduced. Ensure that there are no disputes at a later point in time. It has to be irrevocable to avoid the provisions of clubbing. Winding up, you may have to provide for. Whether you really wind up or not is a different matter. Amendment may have to provide for, and merger, dissolution, and conversion. All these provisions will have to be provided for, whether there's a requirement of, whether there's a provision in the trust law or not, so that at a later point in time, if the contingency were to arise or there's a subsequent amendment in the law, you are able to take advantage of the provisions. Broadly, make the trustee very exhaustive, provide for all contingencies, do not leave out any particular aspect thinking that the matter will settle itself. Basically, a dispute starts, it will start festering, and it will actually only make complicate matters, and things don't settle down at all. And the litigations will be very prolonged and very expensive. Now, one question which was put was, what are the precautions as far as the trustee is to be considered? Registration of the instrument of trust is absolutely essential, irrespective of whether there is movable property only. Because without an instrument of registration, there is no evidence. You can't establish the existence of trust before the tax authorities while dealing with any other property matters when you want to buy. So it is necessary that the instrument of trust has to be registered. Do not consider the tax benefit alone. Tax benefit vis-a-vis the risk of loss of control over property is very essential. In the current situation, where separations and divorces are very common, permitting a startup founder, a young startup founder, or a young executive to settle all his property in the name of a trust for the benefit of his wife and children and so on, could result in problems later because he may be deprived of the property. Examine the situation very carefully, examine the assessee's requirements, and find out what kind of a solution would work out in case these contingencies arise. You may not be able to discuss it with him. Maybe with certain people, you will be able to tell them very clearly that you will have to take note of this fact. It's very similar to a property being willed out by a senior by the father, and instead of willing it, giving it as a gift to the son. When he gifts it away, he loses control over the property, control over the income, and the net result will be that he could land in trouble at a later point in time. So the better thing would be to will the property. Similarly, when you make a trust, you should appreciate that the property is given away for good, and therefore there has to be some kind of a discussion and assessment of the situation before you decide on the trust. And tax benefit should not be the sole criteria. The risk of loss of property, control over property is very important. Business through trust, there is a risk of tax at MMR unless it's a declaration through will, which we have discussed already. Clubbing provisions are to be considered. So you will have to take note of 61, 62, 63, and 64 of the Income Tax Act, read them very carefully, and assess whether the clubbing provisions would apply. Trustees should be capable, reliable, and honest. This is actually a very difficult condition for you to ensure. They could be capable, reliable, and honest at a given point in time. A couple of years later, they may not be reliable, or their own personal situations may turn out that the capability itself has also reduced considerably. So these things will have to be taken note of. Normally, if you find these trusts are normally manned by the trustees are actually the close relatives, and there is an age profile, and it's generally thought that they will take care of the interests of their children. But where there are third-party trustees or independent trustees or even institutional trustees, you will have to take care. Discretionary trusts are not really a good option unless there are specific requirements, specific needs because of the tax laws. Now, drafting of the trustee, you will have to take care, which were discussed extensively in the earlier pullout. The conditions in the trustee, what are the powers, everything is to be very clearly made out. Decision ultimately should be of the assessee. The decision should not be of the chartered accountant or the lawyer. Leave it to the assessee, explain the implications very clearly, and explain the implications in his specific context, in the specific context of the asset profile which he has. Only based on that, the assessee will be able to take a decision and ask him to discuss with his own family members before coming to a conclusion. Stamp duty implications, you will have to take note of. I gave you the example sometime back of a trust holding an immovable property in Bangalore, which when it had to be distributed among the trustees, ultimately the stamp duty had to be paid on the current guideline value. Trusts in favor of non-relatives is not a very safe proposition because of the income tax implications, especially of immovable property. So a lot of caution should be exercised. When you make up a trust, you ensure that you understand the trust law, understand the Transfer of Property Act, and understand what is the requirement of the individual concerned, and also the area of the applicable law. For example, if you're going to if the trust is going to be given away when there is a tax dispute, Section 281 of the Company, 281 of the Income Tax Act has to be taken note of, because transfers in that kind of a situation could result in the transfer being treated as a fraudulent transfer under the Income Tax Act. And similarly, under the Insolvency Code, there are specific provisions which will bar transfers, and that has been taken note of. I'll give you another example. If there is a property, say in UK, and you want to settle it in favor of an individual, if the individual is prevented from owning that property in UK on account of any specific requirements of the UK law, then the trust will be considered as illegal and there will be an issue. So you will have to consider all these aspects before making the settlement. Defeating any provisions of law through a trust is actually illegal under Section 4 of the Section 14 of the CPE Act, under Section 4 of the Indian Trust Act. There is another concept called rule against perpetuity. This is under Section 14 of the CPE Act. Basically, what it says is that the property cannot be you cannot tie up the property forever and make it inalienable for an indefinite time in future. I'll give you an example. A fund is bequeathed by A for his life, and then after that to B, and after that to B's sons when they attain the age of 25 years. Now, you could have a situation that when he attains the age of 25 years, none of the other people are really around. That trust will be considered as illegal. So take note of this particular provision, which is elaborately discussed in the Commentaries on Transfer of Property Act, that is ruled against perpetuity, and any trust which is made out which is in violation of rule against perpetuity. Actually, even in the case of a will, under the Succession Act, the rule against perpetuity cannot be violated, and you will get into a problem. That was 114 of the Indian Succession Act. Now, as far as the youngsters are concerned, normally will is preferable to trust unless there are specific reasons. Family discord is a major issue as far as the young people are concerned at this point in time in our society. So that cannot be ignored. In the case of certain types of business, suppose I'm a businessman with about 4 or 5 different types of businesses. I could have a main trust in which all the children are beneficiaries, and sub-trust created in favor of various beneficiaries, individual children, and these sub-trusts will generate sufficient money to take care of will run separate businesses and will go to the benefit of the individual beneficiaries. This can be one mode of settlement. There may not be a single trust. There is one parent trust and there are sub-trusts. The other issue is multiple trusts may be required for multiple business lines. You have one in transport business, the other one is in finance, and the third one is say in trading. You may require different types of different trusts to take care of these multiple business lines. Large institutional trustees are an alternative where you do not have anything else except, say, substantially movable and movable property to take care of, and there are no businesses involved. They are normally, you appoint a portfolio manager, you appoint an advisor, but these large institutional trustees are quite expensive because at the time of formation, there has to be a fee, and on a regular basis, there will be an institutional fee to be paid to them on a yearly basis. Next is, you will have to appoint mentors to oversee institutional trustees. This is very important because institutional trustees are actually run by professional managers who may change over a time or who may not be, who may retire. In all those cases, you will have problems, and there has to be somebody to ensure that their work is overseen. Before you do anything else, there is a need to assess the financial viability of a trust. That is, or do you consider trust as an option in a given case, considering the value of the property, considering the value of the money? If you have one house, unless you have an incapacitated successor or a differently able successor, trust may not be an option. But if you have multiple properties in different locations, multiple investments, and there are also successors who are likely to litigate or rather impending disputes which are arising even otherwise, then it may be financially viable to make a trust and also ensure that it functions. In certain cases, you may decide to have a trust and will. That is, you may have a mix of both trust and a will. So these are things which have to be decided based on the financial viability and based on all other factors like the nature of the property, the nature of the beneficiaries, impending disputes, the existing disputes, and discord within the families. Now, tax on gifts and donations will have to be taken note of, whether it is liable for any amount of income tax, and if so, whether the consequences assessed, and what will be the liability, and whether the liability is provided for. And the bank accounts, you will have to ensure that proper bank accounts are provided for, and maybe in multiple banks to ensure that there is a smooth movement as far as the trust is concerned at a later point in time. Now, when in the case of traditional family businesses, you normally have a different model. You have a trust which is intersposed between the promoter and the company. That is, the trust holds the shares, trustees will hold the voting rights, fragmentation of votes and decisions of majority, which can be stifled by a minority, is avoided, disputes are avoided, and dissatisfied legal heirs will not create any problems, and the trust will manage the whole show. But the entire thing depends on how reliable and how capable the trustees are, not only in the short run, but in the long run. You have got examples where large companies have created such trusts, transferred their holdings there, and they have even taken necessary approval from CPE for the takeover, under the takeover regulations. So this is one aspect which could be considered, where there are traditional family businesses which are substantially in value, and the successors are not either capable or not interested, or there are disputes among the successors on how to carry out the business at all. The advantage in the case of a trust is that there is a protection of family wealth. If you have, say, 3 properties, 3 floors in a particular building, if 1/3 were to be given to one building, was to be given to each of the 3 successors, it gets divided. And each successor will be able to sell the property to a third party, which would further dissipate the value of the other 2 successors. You cannot prevent him. It is in these situations that the property can be protected as a single property through a trust. But this I'm giving you as a simple example. But you will normally create a trust where there are multiple properties with large values. You take another situation. If you have a property in one location where the value and the rent is very high, and if you have a property in another location where the value and the rent is not high, and if you have investments similarly in different companies where the value varies, return varies, division may become difficult. Ultimately, what will happen is the successors will have to be jointly holding all these investments and properties, which will result in its own problems at a later point in time. To avoid this contingency, you could have a situation. You could create a trust and ensure that the property is owned and controlled by the trust and managed by the trustees, and the beneficiaries get the equal share or whatever is the designated share out of the entire income of the trust. The advantage in a trust is that the individual beneficiaries can pursue their own line of interest. They can run a new business, or they can pursue music and art, or be retired and be at home, and they'll continue to get the stream of income. And while the other active successor may get involved in another business of its own. Because normally you have 3-4 successors. The 3-4 successors may not be equally competent, may not be equally involved or equally interested in the business. In such a situation, the trust as a mechanism will help you in ensuring that there is a proper division and proper division of the money which you earn. Now, let's come to certain case laws. Induvati Kirloskar is actually a judgment of the Karnataka High Court. It's reported in 176 ITR 422. It's an excellent judgment, which is a must read for all of us who are interested in trust. In fact, the quality of the assessment order, the quality of the advocacy, the 2 lawyers from the departmental side and from the assessee side, and the quality of the judgment are actually really superlative. When you read this, you very clearly understand. It's not a very long judgment, and you know how the whole thing operates, and many of the aspects of the theory of anticipation, the theory of coverture, all these which are actually are not very elaborately discussed in the texts which we read, which we as chartered accountants read, are all covered in this particular decision. In this particular case, the senior most member of the family, L, formed a trust. The trust was for the beneficiary for the benefit of his 4 daughters-in-law. After the daughters-in-law, they were to be succeeded by the sons. And after the sons, it was to go to the sons. It was to go to the grandchildren rather. So there were 3 lines of beneficiaries: the daughters-in-law, the sons, and the grandchildren. Now, at a certain point in time, sometime in this case came up in 1969. So sometime 1989, sometime in the 1960s, 70s, one of the daughters-in-law decided that she will release her right over the property. So her trust interest was released in favor of her husband. The husband, in turn, immediately released it in favor of their child, who was actually a beneficiary. The department argued that under Section 58 of the transfer, under the Section 58 of the Indian Trust Act, this particular transfer was prohibited. I'll just read Section 58. The beneficiary, if competent to a contract, may transfer his interest, but subject to the law for the time being enforced, as to the circumstances and extent unto which he may dispose of such interest. But please listen to the proviso, provided that when property is transferred or bequeathed for the benefit of a married woman, that is where the property is for the benefit of a married woman, so that she shall not have the power to deprive herself of her beneficial interest, nothing in this section shall authorize her to transfer such interest during her marriage. This is a very important clause. What it actually says that where the property is for the benefit of a married woman, she cannot transfer it. She doesn't have the power to anticipate. Power of anticipation, right of anticipation is what the technical term which is used to transfer it to anybody else. This particular restriction was imposed because to protect the interests of the married woman against a husband and in anticipation of income or in anticipation of increased value, she should not be deprived of the property. So when the property has been transferred or bequeathed for the benefit of a married woman, she shall not have the power to deprive herself is actually a provision even in section 56. Now, in this context, the department argued that under section 9, only as Bharadwaj discussed this a couple of minutes back, under section 9, only an intending beneficiary can transfer, and that was rejected by the court. Then the next question was, is it a transfer during kavachan? Kavachan is actually during the married life and in anticipation, which was prohibited by the trustee. The court ultimately came to the conclusion that all that happened was that there was actually she jumped the succession in the sense that after her, it had to go to the father, her husband, and after her husband, it had to go to the son. By the entire thing which took place, the son got the property immediately. And when the son got the property, he was already a beneficiary. He was not a third party to whom there was any alienation. There was no alienation, there was no transfer. All that which happened was, what is it? Yeah, that is, all that happened was acceleration of subsequent interest. That is, a person who wants to get the right over the property at a given point in time or many years later, got the right over it immediately. So that was a decision in Indumati Kirloskar. This decision is interesting because it enables you to understand certain concepts under the Indian Trust Act. Another important decision is actually Kasturbai Walchand Trust, which is 63 ITR 656, which is of the Supreme Court. In this case, the trust was set up by Walchand and his wife K, Kasturbai. And trustees were W, K, and some relatives. And trust was for the benefit of the K. That is, Kasturbai was to be the beneficiary of the trust. Right of residence, that is, the immovable properties owned by the trust, could be occupied both by Walchand and by Kasturbai was the clause in the trust deed. Now, at a certain point in time, and after the death of K, the property was to be deployed for charity. I think this was one question which was raised some time back, and that is answered in this particular decision. Now, what K did was during her lifetime, she surrendered her interest, and she also said that the surrendered interest is to be used for charity. This was questioned by the department, and in the context of Section 58, and it was held to be valid by the Supreme Court. And the Supreme Court further held that trust was to be deemed as charitable in nature, and the income in its hands would be free of tax because it was being used only for charitable purposes. This is actually an important decision in the context of trust law, succession, and also yearly exit of the beneficiary in favor of charity or in favor of some other purpose. These three cases, Indumati Kirloskar, Kasturbai Walchand, and Vimal Kishore Shah, are a practical use as far as the trusts are concerned and trust law is concerned. Now, certain other issues, oral trusts are permitted, but will be liable for MMR under Section 164A, and so the oral trusts are not to be done. You will have to make a trustee and also register the trustee. Registration is essential if there is an immovable property involved. But for proving and for establishing a trust, you need a trustee. Take care of the clubbing provisions under Section 60, 61, and 64, and ensure that you do not get into indirect transfer, which will cover circuitous and interconnected chain of transfers under Section 64. And capital gains on transfer by the transferee will be clubbed as per the Seventhilal Maneklar Shade case, but these are all issues which will be discussed possibly tomorrow. So I'm not covering it at all. I think we have another 25 minutes. Any questions are there? We'll take
Yes, sir.
it.
One question is, so you mentioned in case of will probate, stamp duty. What is the stamp duty, sir?
See, based on the value of the property, an assessment is made and then the stamp duty has to be paid, remitted to the court, and only then the probate will be issued.
Is there any fixed percentage or how exactly?
I think I'm not very sure of what the percentage will be. It will be less than the normal rate, which is for conveyancing. I can confirm. I don't think it is not the same rate as conveyancing, but 2 or 3%.
Okay.
But sir, I'll just point out one thing. The requirement for probate is imposed under the Indian Succession Act only in the jurisdiction of the chartered high courts. That is the high courts of Calcutta, Madras, Bombay, etc. So in the state of Karnataka, as of now, there is no, I mean, not as of now, I seriously doubt will come in the future. There is no requirement in the state of Karnataka for probate. So within the jurisdiction of the High Court of Madras, Bombay, etc., probate will be required.
Okay. Here
Yeah.
will with the registered will is there, then that suffice.
Yes, that's suffice. As I said, registration is not mandatory but strongly recommended.
One more question, sir. In trust deed, whether beneficiary also needs to sign?
No, sir. Beneficiary is not a party. In fact, the Trusts Act the common law on trusts doesn't even require that the beneficiary needs to know about the trust.
Know about that.
A beneficiary without notice of the trust is entitled to the beneficial interest.
In case only with the current trustees and the settler needs to sign.
That's no. Even the trustees do not need to sign. If the trustees do anything subsequently to indicate their acceptance of the trusteeship, that is sufficient. But as at least one trustee should sign. But as a matter of practice, it is recommended that all the trustees and the settlers sign. Okay. In fact, in a will, when we draft wills, we recommend that the beneficiary of a will, that is a legatee, must not attest as a witness, because there will be some doubt in the mind of the court if there is any dispute as to whether the will was legitimate. In the same way, we actually do not recommend strongly against beneficiaries executing the trustee.
Okay. So in one more question, in case of specific trust, can the creditor be able to attach the share of the beneficiary?
Yes, there is a provision in the there are two. I mean, there is a direct judgment of a high court on this. I have forgotten the citation, but there is a provision in the Civil Procedure Code which lists the properties which are subject to attachment in the execution of a decree, which is the same procedure which applies for tax recovery proceedings and all that. So if the creditor obtains a decree from the court and in the execution of the decree he wants to attach property, the beneficiary's interest held in a trust by a trustee may be attached. There is a provision to this effect in the CPC.
But the same thing is not possible in case of discretionary trust.
No. There is nothing in the CPC which says that which distinguishes between a specific trust and a discretionary trust. But then you will have to determine what the share is. The moment he has a present interest, there will be a problem. But I'm not sure whether the law is particularly clear on this.
Okay, in discretionary trust, it's the discretion of the trustee. How can the attachment comes?
Not
if
necessarily, sir.
Comes as my discretion not to give him anything.
Not necessarily, sir. First of all, the trustee has a duty of impartiality, which is laid down by a section in the Indian Trust Act. Secondly, the definition of discretionary trust is very wide. If there are 3 beneficiaries named and you don't mention the shares and there is an obligation of impartiality and subsequently the beneficiary gets no interest, that would also constitute a discretionary trust. So a discretionary trust does not mean that the trustee must have absolute discretion. He can have limited discretion also. You can say, for example, that there are 3 beneficiaries A, B, and C. Each of them will be entitled to 1 lakh per year. Anything above that will be at the discretion of the trustee. Even this is a discretionary trust. So how much property will be attached, how it will be attached is a matter that will have to be judged on a case-to-case basis.
No, then the question of how to protect the property of these beneficiaries or the settler, how exactly that works? If a creditor is able to attach?
No, the settlers' rights, settlers are only to be protected as far as the trust property is concerned. The settler gives the property away to the trust to ensure that suppose
settler becomes insolvent, whatever given to the trust is protected.
No. That is protected definitely.
That is
He has
protected.
given it. That is protected. That's the reason why the trusts are used as a mechanism. Whereas you are talking about the next step.
Next
What
step, when
happens
the
to
beneficiary become insolvent, it is not protected.
Because
So
it
this
is
can
become-
go away.
Just to clarify, sir, if you remember when I was dealing with section 6 on the creation of trusts, if the
Yeah.
settler and the trustee are not identical, then there is a transfer from the settler to the trustee, which means there is divestiture of ownership in the hands of the settler. After that, the property is out of his hands. So any proceedings against him will not result in the attachment of the trust property. However, under the old Companies Act, we had this provision on a fraudulent preference in the liquidation provisions. Similar provisions are there in the Insolvency and Bankruptcy Code. Fraudulent transfer provision is there under the tax recovery provisions in many taxing statutes. These provisions state that when in anticipation of liquidation of a company or in anticipation of enforcement of a collection of a tax, recovery of a tax demand, you carry out any transfer, that transfer is held to be void. So
Void, yeah.
if your bona fide transfer is done, the settler is protected.
Okay. So one more question. In case of uh, trustee become insolvent, this trust property is not at all affected, no?
No, sir, absolutely not. The
Anyway,
trustee
it is for the benefit of the beneficiary. So he is no
Absolutely.
just a trustee only. He is not. It is no owner.
Absolutely.
Okay, sir. That's all. That's all my questions.
So in that case, there were 2 or 3 subjects which I did not complete.
Yeah, please. You have another 20 minutes.
Yes. Subject of vacation of the trustees' offices, there are 2 modes by which a trustee's office is vacated. The first is death and the second is discharge. Death is of course fairly obvious. The question is when is a trustee discharged, or what are the modes of discharge of a trustee? Firstly, when the trust is extinct, obviously. Secondly, even if the trust is not extinct, when he has completed his duties under the trust, then he is discharged. Then thirdly, if there is any means prescribed in the instrument of the trust itself, then he is discharged. So if the instrument of trust provide, say, for retirement in any manner, either voluntarily or retirement by rotation, in all these circumstances, the trustee would be discharged. And if there is an appointment of a new trustee in place of an existing trustee, and there are separate provisions for that which we will come to, then in such a case also the existing trustee is discharged. And finally, if there is consent of himself, there is a trustee himself and the beneficiaries who are competent to contract, then he will be discharged. Of course, as in various other provisions, if there is the trustee also has a right to file a petition for discharge before a principal civil court of original jurisdiction. In such a case, he will be discharged. A question has come from Sriram and Varnarayanan as to can the trustee continue as a trustee if he is declared insolvent? No, the trustee cannot continue as a trustee if he is declared as insolvent. There is a specific provision which I do not recollect now. The answer is no. But I don't think, I don't know how often individuals these days are declared as insolvents at all. There is another question. Shri D. Mohan asks, if the trustee says trustees are permanent, what is the option to remove a trustee if he is misbehaving in the trust activities? This is a question that came up earlier. There is no direct legal remedy for this. However, Section 60 confers a right upon the beneficiary to have a proper trustee. In fact, that is there in the next slide, so I might as well deal with it. What Section 60 says is that the beneficiaries have a right to a proper trustee. Section 60 goes on to define who is not a proper trustee. The first is a person domiciled abroad. The second is an alien enemy. A third is a person having an interest inconsistent with the beneficiary's interest. A fourth is a person in insolvent circumstances. Therefore, I may point out that the earlier question on insolvent trustee is answered here. But the question was whether an insolvent, a declared insolvent can continue as a trustee. This only gives the beneficiary a right to seek his removal by virtue of his being in insolvent circumstances. I don't even think insolvent circumstances constitutes a declaration of insolvency. Even undischarged insolvency or even prior to a declaration, if he's insolvent circumstances, even that would entitle the trustee to have him removed. So in all in these cases, these categories of trustees are treated as not proper trustees under Section 60 of the Trusts Act. And a beneficiary has a right to proper trustees. Therefore, he has a right to institute a civil suit and say that this trustee is problematic, he is defrauding, etc. And on that basis, seek a declaratory decree or some other appropriate order from the civil court holding that the trustee cannot continue in office and he is not a proper trustee. This is one option. So this is the in legally, theoretically, this is the most appropriate option. But of course, there are a lot of other things you can do. You can institute proceedings against him personally under Section 23 of the Indian Trust Act, seeking compensation for a breach of trust. And thirdly, you can also institute criminal proceedings for criminal breach of trust under Sections 405 to 409 IPC as applicable. Essentially, in practice, what happens is that you must find one way or the other to exert enough pressure on the person to, to get him to do what you want. So yeah, we were dealing with the modes of discharge. Section 72 also contemplates that a petition, an application can be filed before the principal civil court for discharge. If the court finds that there is sufficient reason to discharge the trustee, then discharge the trustee and direct that his costs be paid out of the trust property. This is yet another option to get a trustee out. However, Section 72 provides that a petition to discharge can only be filed by the trustee himself. So the beneficiary cannot approach the court under Section 72 seeking discharge of a trustee. Neither can one trustee approach the court under 72 seeking discharge of another trustee. So essentially, this only covers a case where he voluntarily wants to get out. If the trustee doesn't provide for resignation and all that, this is the suitable option for the trustee himself. There are also various circumstances in which a trustee will have to be replaced. One is if the trustee disclaims. You will recollect that a disclaimer by a trustee is only possible before he actually accepts the office. Once he occupies the office, he cannot thereafter renounce it. So if he disclaims, then he will be replaced. The second is if a trustee dies. The third is if a trustee is absent from India for a continuous period of 6 months. If he leaves India for settling abroad, if he is declared insolvent, again, the question is answered here too. Then 6, he desires to be discharged. 7, he becomes unfit or personally incapable of acting as a trustee in the opinion of the principal civil court, or he accepts a trust which is inconsistent with the existing trust. In all these cases, new trustees may be appointed in place of the old trustees. However, in none of these circumstances is there a mandatory condition that a new trustee must be appointed or that the existing trustee must be replaced. Once again, these requirements are not mandatory. Therefore, it is only if you approach the court if you choose to approach the court under some appropriate provision, you can seek this relief. But it is not as if he is automatically vacated under any of these circumstances. It is only under 71, that is modes of discharge, and where there is a petition for discharge filed, that the office is vacated. Now, if if the now in a situation where any of these 6 or 7 circumstances occur, who will appoint the trustee? The trustee, will you have to go to the court each time? That is where a trustee has to be replaced. First, if the trust deed makes a provision that a trustee may be replaced in a particular manner, then that that will be followed. Secondly, the author has a right to replace a trustee and appoint a new person, provided that the author is competent to contract. Therefore, if the author is a minor, he may not be able to do so. Again, here it is unclear whether the civil court can perform this function in the place of the minor, as some other provisions, as we discussed earlier, had provided. Then also the surviving or continuing trustees may also appoint. The mode of appointment under any circumstances must be in writing and under the hand of the person making it. If it is impracticable to appoint the trustees in this manner, then the beneficiary may apply to the court for appointing. That is again only in these 6 or 7 circumstances the beneficiary has a right to apply to the court for appointing. But in going to the court in this circumstance, he has to prove not just that the trustee suffered from those incapabilities, but also that it was impracticable to appoint under section 73. Therefore, that is appoint either by the author or as per the provisions of the trust deed or by the trustees. And therefore, the burden of proof to be discharged by him is a little higher. The Act, that is section 74, further provides that where such an appointment from the civil court is sought, the court must necessarily have regard to the wishes of the author as inferred from the instrument of the trust. Therefore, these wishes cannot be inferred on the basis of the trustee giving evidence, for example, that the author said something. That is not permissible. The instrument of the trust, if it depicts any of the wishes of the author, then that must be considered. Then, in such a situation, also the wishes of the persons who are empowered to appoint the trustees under the trust deed, and the question of whether the appointment will impede or promote the execution of the trust, and the interests of all the beneficiaries. The court is bound under section 74 to consider all these questions in determining who will be appointed as the new trustee. Now, we have already seen earlier that if you look at section 75, we have already seen earlier that when a property is settled upon trust and the settlor and trustee are not identical, then there occurs a transfer of property from the settlor to the trustee. Now, I have also said when some question was put that where a trustee retires and a new person comes into his place, there could be a transfer. This was in the context where there is identity between the settlor and the trustee. That is, the settlor and the trustee are the same person. And thereafter, the settlor retires and a new trustee comes in. Is this a means of avoiding stamp duty? I had answered no. However, if the trustee is not appointed in accordance with the terms of the trust and there is no ordinary course of appointment, and the court appoints the trustees either under section 73 or section 74, then not necessarily the court. If any appointment is made under 73 or 74, section 75 provides that the property will automatically vest in the new trustees. Logically, the implication of this is that there is no, where there is an automatic vesting, there is no transfer and stamp duty will not arise. Finally, where trustees, where one out of several co-trustees either die or they're discharged and therefore vacate office, the trust continues. It is to this extent, to this very limited extent, there is a similarity with the company in that there is perpetual succession. But you cannot say that where one of several co-trustees die or are discharged, the trust itself ceases to exist. But again, this is subject to express statements in the instrument of trust. So these are all things which should be contemplated at the time of settling the trust and incorporated in the trust deed. One of the most important rights of the beneficiaries is the right of the beneficiary to transfer his beneficial interest. This has already been dealt with in dealing with the principles of anticipation by Kavacha. Sections 56 and 58 of the Act impose certain restrictions on the transfer of beneficial interest by a married woman. Subject to that, a beneficiary has a right to transfer his beneficial interest. But in order to be able to transfer, the beneficiary must necessarily be competent to contract. There are any further questions? Oh, there are quite a few questions. One is, what is the difference between appointing an individual trustee and a corporate trustee?
See, if you look at the difference between an individual trustee and a corporate trustee is that there is an institution in the case of a corporate trustee. Normally banks and several of these private banks accept to be trustees. And there is a clear hierarchy. There is a proper setup. And many of the problems which you have on account of personal animosity and relationships which exist in the case of individual trustees may not be there in an institutional trustee. But in the case of individual trustees, if they're personally and closely related to the beneficiaries, there is a certain attachment, and so the things may be done with more care. Institutional trustees may be more capable while handling financial investments, for example. For example, if there is an individual who owns properties in India and abroad, or if he has a lot of substantial financial investments in mutual fund shares and so on, managing it may require expertise, which an individual trustee or a relative may not have. So these are the two differences. These are the major differences between an institutional trustee and an individual trustee. Institutional trustee obviously carries with it a cost of setting up and cost on a recurring basis annually. But even in the case of institutional trustees, as I have said in the case of my talk, that there is a need for a mentor so to oversee what they do, so that overall the interests of the beneficiaries and the interests of the trust are taken note
of. When another question is, when the son gets married and undergoes a divorce, will the daughter-in-law get a right over the property of the trust? See, most of these questions, I don't practice family law, I'm not competent to answer this, but most of these questions are considered by the family court while granting the decree of divorce. And this is dependent on the contentions taken by both parties, and the separation of property in the context of a divorce will come within the jurisdiction of the family court. So it's not possible to lay down a single uniform principle. It will depend, of course, on the facts of each case. I'm proceeding on the basis, of course, that the son is the beneficiary of this trust. And of course, the trust ought to be genuine. Then another question is, can all stakeholders agree to dissolve the trust and distribute the property as provided in the trust deed ratio?
Yes, we had a case where this happened. As I told you, there was a very, very substantially movable property in Bangalore. There were 3 beneficiaries, and they decided that they would dissolve it. And so 1/3 portion was registered in the name of 3 individual beneficiaries by paying the appropriate stamp duty. They later on sold the property, got the benefit of Section 54 also. So it is possible. In fact, the extension of trust normally takes place by the ultimate beneficiary getting the remainder.
Regarding that, my question, suppose trust itself sells the property, since the 3 individual 3 beneficiaries, they are not eligible to claim 54 if the trust sells the property?
See, there is a Bombay High Court judgment, AMY, AMYCAMA. I'm not able to get the citation. If I get the citation, yes, it is 237 ITR 82. 237 ITR 82. And there is also one more decision, Sri Krishna Bandar Trust, 201 ITR 989. In all these cases, the standard practice under the Income Tax Act is that status of assessment will be that of the beneficiaries. Therefore, if individuals are beneficiaries, the assessment will be as individuals, in which case exemption under Section 54, 54 of ATC, etc. will be available. Also, you can refer to Section 161(1). This is a legal position. But many times, it is actually difficult to convince and go through with the assessment procedure at a practical level. That's why in this case, the decision was taken that we would rather pay the stamp duty on the guideline value, separate it out, and then decide whatever they want to do. Because you could have a non-resident who may want to remit the money abroad after paying the taxes, or you could have a resident who may already be having houses, or he may not be interested in having another house. So because of that, these issues could come up. But basically, you are right that the status of a trust is that of the beneficiaries. So AB comma is actually a standard proposition on this issue.
Thank you, sir.
The next question, consequent to the earlier question on distribution of the property amongst beneficiaries, will that be liable to capital gains?
No. They have the beneficial interest over the property. So the question of capital gains at the point of distribution doesn't arise. The trust distributed the property 1/3 each to the 3 beneficiaries. At that point, there cannot be a capital gain. It is their own property. See, they have the beneficial interest. It's only the subsequent sale of that beneficial interest to third parties which resulted in a capital gain.
So the tax law always very often disregards the de jure position and only looks at the de facto position, which is why this conclusion arises.
In fact, in one of the Supreme Court decisions, I'll tell you the decision also. I think it's been actually in the Kasturbai Walchand case, the Supreme Court stated that when a trustee is executed, the property vests in trustees and income is of the trust. That taxing is in the trustee's hands in the like manner and amount as beneficiaries is another issue. So this is an aspect which you should actually appreciate. In normal civil law, the income is that of the trust and income is that of the property vests in the trustees. But the beneficial interest rests in the hands of the individual beneficiaries, and taxing under the tax laws will be in the hands of the trustees in the same manner and in the same ratio as in the hands of the beneficiaries. And that was the proposition which is explained in Kasturbai Walchand case.
You should also look at the decision of the Supreme Court in M.R. Doshi's case, where the Supreme Court, this is a case of a minor beneficiary. The question was whether clubbing would apply under the erstwhile section 64(1) clause 5, now substituted by subsection 1A. This is very short. I won't deal with it because it's not within our scope. Very briefly stated, the Supreme Court under the old law held that if, for example, trust property for the benefit of a minor is earning, say, savings bank or fixed deposit interest, and the trust says that the entire interest, the bank balance, everything can go to him only at the age of 40 or only at the age of 25. The Supreme Court said that in such a situation, no income accrues in the hands of the minor now when he is in his minority, and therefore clubbing cannot take place. And it can only clubbing, if in order for clubbing to take place, there must be approval in the hands of the minor during his minority, which is absent in this case. Anyway, I don't want to go into that in detail.
My question that now this M.R. Doshi case is not holds good, sir, in the current law.
I didn't want to answer that, sir. But prima facie, it may still hold good. But this is a question I would recommend you put to Sri Sangvi on Saturday.
Okay, tomorrow.
This is actually a disputed question, and it's a very aggressive view to take that it is still applicable. Prima facie, I see no reason for it to be not applicable. But I haven't spent time doing enough research on it first to say it with any sense of authority. In any case, nothing either of us is saying today is professional opinion or professional advice. I think after the questions you have asked, I feel compelled to make that disclaimer.
No. One more continuation of that. See, in that case, minor, suppose the age they set is 25. So when he reached the 25, the whole income of all accrues at that time.
Capital receipt.
It becomes a capital receipt.
Yes, that is one possible view. That in fact, there is a. Again, sir, I'm very reluctant to answer this question, but prima facie, that is a possible contention.
Yeah, Saturday we'll pose this question again.
Actually, in the case of some of these issues, it's better to take a conservative view to avoid prolonged litigation.
Yeah.
You know, the point is individuals, and especially who are abroad or who are older, may not want to take litigation and pay the 20% tax and file the appeals and so on. So where the decision is likely to be only at the High Court or ITAT level, you may want to take a decision which is safer and sort out the problem at the lower level and finish it off.
Thank you. Past our time. So
So one more
So any
question,
more
I think in
Oh,
the
yes.
chat box some question is there.
In the case of sir, what if trust is formed for beneficial interest of saving general public? Let us say renting a conventional hall but not registered under 12A. How about taxation of this? Sir, this question is fraught with controversy, and further it is a question on taxation. I apologize, but I would request the queries to put this question on Saturday.
It could be assessed as a BOI, for just as a hint I'm giving you.
Let me tell you another extremely dangerous hint. In the case of a charitable trust, when you receive income, what you claim under in your computation is application of income to charitable purposes. Application of income is theoretically different from expenditure incurred on earning the income. If a charitable trust does not have exemption, it will be taxed under the head other sources, not under business, because there is no profit motive. Under other sources, if you look at section 57, it says that what can be deducted out of income is expenditure incurred on earning income. Application of income is not expenditure incurred for earning income. So theoretically, it is possible that you will be taxed on the turnover at the turnover level. The only thing is, so far in our experience, the department has not reached this view yet. So this is extreme controversial territory, sir. I leave it to the people who are addressing tax.
No, we do have a notice for revision under 263, where in the case of a charitable trust, because exemption was denied at the lower level, the CIT exemptions not in Karnataka, but in northern state, has issued a notice under 263 stating that the gross amount of donations without any exemption, without any application, will be subject to tax. So the only alternative before us was to file a writ petition. We have got it stayed recently, and that's where we are.
Okay,
Once
sir.
again, I
People are
can't say this,
asking your presentation, sir. I request you to share it.
That anyway, I thought we will always send, sir. That's not a problem. That will be
Okay, sir. Okay. Any other questions we left?
I think one is there, sir. In the case of ESOP trust, the trust has subscribed to shares and not allotted to any one employee. Settler and trustee are the same. No activity is made in trust except initial subscription. Can the trust be extinguished and return the shares held by trust to trustees and dissolve the trust?
I don't think it's actually not within the scope of this particular discussion. So we were specifically told that only the business situations are to be covered. So I think, leave it at that. Anything
So
else?
I think we covered all questions. So some of the appreciation also come from the attendees. Excellent deliberation. Thank you. I think we had a fantastic session, sir. Excellent practical experience. All the questions you shared, really, I really enjoyed. The whole 3 hours I was fully active and I was listening carefully. So excellent session. Thank you very much, Sheshadri, sir. I request you to come on Saturday also. So if possible. So
Saturday we may not be available, sir. We can't make promises now. We will let you know.
Oh, Saturday we are not here. We are not in Bangalore, actually.
We are not in Bangalore on Saturday.
Okay. Thank you very much, Bharadwaj. Excellent presentation. Both of you really have a wonderful experience in this, vast experience on the whole subject. Thank you very much. I think I already requested our succeeding next vice chairman also to conduct this kind of program more number of times. Maybe we have one more in sometime in December or January regarding will and other things. I request you to share your experience. Thank you very much. Thank you very much, participants, for your active participation. Thank you all. See you on Saturday, 4 p.m. Thank you. Thank you very much. Bye.